Yes, Mr. Wire.
Hey, please, Your Lordship. My lord, I am praying for a posting of a urgent writ petition Friday, my lord, if it is not inconvenient for your lord. Obliged, my lord.
My lord, I have a prayer for listing of a writ petition, Your Lordship. My lord, several location, my lord, taken as a further hearing, my lord.
May I please, Your Lordship?
Oh, probably.
May I please, Your Lordship? I beg to mention item number 11, Lordship. Last occasion, Your Lordship directed me to prepare the list of the but yesterday I have received the list from Mr. Bordlo. So I
Okay.
pray for sometime Monday, Lordship. I will provide the list, type copy of the list, Lordship.
You are not there in the case.
No, I'm not. I'm on behalf of Mr. Mohan, TJ Mohan.
On the prayer of the learned counsel for the petitioner, registry to list this matter again on 4/6.
May I please, Your
Of
Lordship,
guidance.
with the consent of others, I beg to mention item number 17, Lordship. I'm praying for an adjournment for 2 weeks, Lordship.
Why?
Lordship, my senior has some personal difficulty to relate.
Dasgupta. Prayer is made on behalf of Mr. A. Dasgupta, learned senior counsel, for an accommodation in the matter today on account of personal inconvenience. For some prayer accepted, matter stands adjourned. Registry to list this matter again after 2 weeks on a date to be fixed by.
Lordship, interim shall continue.
Interim order passed earlier to continue till the next date of.
May it please, Your Lordship, I beg to mention item number 6 of the daily list, Your Lordship. Item number 6, Lordship, we are seeking for an adjournment for 1 week.
The amended writ has not been filed. Let it reach, we'll see. Let it reach, we'll see. You're making a prayer on behalf of Mr. Bishwas.
Yes, Your Lordship. Yes,
I'll
Lordship,
not-
out of patient, Lordship.
I'll not pass any adverse order, don't worry, but let me see. Some irregularity is there, we'll try to resolve it. Be here. Yes,
Man, please. I need to file motion for urgent hearing of the matter.
what is the matter?
The writ petition
Writ petition for what?
against the ESI in the bank.
Okay, what is the issue?
Basically, bank has marked no debit in my account
Hmm.
and it's causing my day-to-day hardship to us
There is a debit freeze in your account
in Delhi.
in Delhi.
Yeah.
And why are you here then?
Basically, the ESI has passed the order from here.
Who are you?
I'm Girish, a petitioner person.
I know that. What are you? What do you do?
Basically, I'm a businessman.
Why the debit freeze was made?
Basically, ESI certificate has been registered from Delhi, from Assam only. That's why they have passed.
There is a claim, ESI claim against
Yeah.
you. For that, they have made a debit freeze.
Yes.
Okay. Next week. Budbar. Next Wednesday.
Can it be today? Hello?
Huh?
Can it be listed today only?
Today, I'm sorry. There is much matter. Today is a hearing day.
Okay.
Wednesday next.
Your Lordship, I would like to make a mention for listing of a writ petition on 29th of May.
May I please, Your Lordship? I like to mention item 34 of supply list.
Why?
Lordship, my senior is going out of station due to some personal.
Who is your senior?
The Lordship PD Nair, as does on behalf of PD Nair. Actually, Lordship, I am not
Prayer
going
is made on behalf of Mr. P.D. Nair, learned counsel for the petition for an adjournment in the matter on account of personal inconvenience. Prayer accepted. Registry to list this matter after 2 weeks.
Yes.
Lordship, a date may be fixed, Lordship.
When will Mr. Nair come back?
Lordship, after 18.
After 18th. 22nd.
Deeply obliged.
3 weeks, yeah?
May it please, Your Lordship, I beg to mention urgent listing of writ petition.
What is the urgency? Your senior told you that is the urgency.
Oh, yes.
What is the urgency?
His representation is not taken into consideration
For what?
for his retirement.
Bench 3 to Moino, eh? It's a bench 3 matter.
It's a,
Bench 3 matter.
I was
You-
instructed to send.
You get your instructions, come back at 11 o'clock. Even if there is a matter, come and mention with the facts. And then I'll see.
Bless you.
Even if I'm in amidst a matter, come and tell her. I'll hear you.
Bless you, Lordship.
But only you should come, not your senior. Both the matters, issues are same.
Same issue, your lord.
Hmm.
This is the second round of litigation, your
Hmm.
lordship.
First one was just
Lordship, but there is one
way,
observation in
making a way or survey of a way for making this road.
the
Yes.
in the first, your lordship, if your lordship comes to that order, at page 176,
Hmm.
I just want to place two lines, two paragraphs, your lordship.
Yes.
This contention of the petitioner that though the requisite
Para
formalities.
12.
Para 12, your
Hmm.
lordship. Change of ownership and peso license in respect of 3 TTs could not be completed within period of 4 months from the LOA for reasons beyond the control of the petitioner as indicated in the reply to the so-called notice. The petitioner with his best effort could complete the requisite formalities before issuance of so-called notice. The said facts have been highlighted in reply to the so-called notice submitted on 7/3/2026. The respondent IOC authorities, while giving consideration to the reply, are required to give due consideration also to the reasons assigned by the petitioner requiring more than 4 months from the LOA to comply. This is what was there, your lordship. The petitioner has stated that the genuine apprehension has arisen that the punitive action as indicated in the so-called notice would be taken wherein no fault can be attributed to the petitioner solely. It is expected that the respondent IOC or authorities shall give due consideration to the explanation provided by the petitioner while taking a call pursuant to the so-called notice. It is further observed that tests are not required, your lordship. Now this is this was the crux of the issue, your lordship, that it was beyond our control, and honorable court, while directing to dispose of this reply, your lordship has also observed that they will give due consideration to the explanations given by us, your lordship. Now your lordship will kindly come to the impugn order, which is at page 213, your lordship.
The reasons are at 214.
Yes, your lordship. 214. The formalities have since been completed before issuance of the so-called notice. The contentions given by you have been carefully considered, and your request for extension of the period has also been examined. However, the same is not acceptable due to the following reasons. Now, your lordship, first reason, both the tenders under reference, that is tender of 2018 and 2025, are independent to each other and does not have any interlink. The extension of the previous contract was done with your prior consent. Your lordship will kindly note these words.
It cannot be yours, they
Yes.
will be earlier honor.
Consent, and you accepted. You were aware that you had applied for the new tender with the same trucks, and there was no compulsions for you to accept the extension, your lordship. Very exception. And as the contractual requirement for the trucks offered under ATS mechanism were disclosed in the tender and were accepted by you, there cannot be any escape route for you upon violation of the stipulated terms and conditions. The very first ground, your lordship, they have on which my prayer has been rejected is your lordship has disclosed non-application of mind, your lordship. It is clear, your lordship, that it is not me. It is the earlier contractor from whom on agreement of we have executed an agreement of sale, and based on which we have participated in the tender process, and LOA has also been issued based on that, your lordship. Now, secondly, you have participated in a tender process with full knowledge of the ATS provisions, including the requirement to complete the statutory formalities within fixed timeline. Accordingly, the undertaking as report per annexure 40 and 41 were also submitted by both buyer and seller. No provision exists in the tender for the deferment and recalculation of the said timeline on account of continuation of any previous contract. The reasons cited therefore reflect operational difficulty, but do not establish a legal impossibility or circumstances that would justify non-compliance of an explicit contractual condition, your lordship. That, your lordship, I beg to differ with that, your lordship, because, your lordship, it is impossibility for us, your lordship, and that is why they have given us a window period of 4 months, your lordship. Out of that 4 months, your lordship, 2 months has gone, your lordship, since extension has been granted, your lordship.
Extension was till 31/10/20.
Lordship.
So the 2 months would be till 30 from 1/1 1/11/2025, if we
Lord-
calculate
Lord-
4 months
Lordship,
for your sake.
Lordship, for us.
November, December, January, February.
Lordship,
So February, you will complete 4 months.
Lordship,
And within this 4 months, you had got all the documents,
Lordship,
conversion,
Lordship.
plus the RC was issued sometime in February.
Lordship. I, para 24, your lordship may kindly come.
Hmm.
Page 12. In respect of this vehicle, your lordship will kindly see, date of transfer was of RC was prior to your lordship, even 12/1, your lordship.
And have you extended this PESO license?
Yes, your
Because it
lordship.
was
That is on
expiring in
11
March.
11
No,
to
it was expiring on March 2026. It
lordship.
expired on March 2026.
Date of transfer of peso license was on
This
11
is only name transfer.
lordship,
The document says, document is at page
lordship. These are your lordship at the
195 is this one.
lordship.
Come to page 200.
2/1, your lordship.
200.
Lordship. Helen from your lordship.
Just after the Hindi line, there is a line. The
Lordship.
license is valid up to 31/3/26.
Lordship.
Now, is this extended?
That instruction I'll have to take.
Because this is a change of the license,
Lordship,
right?
lordship.
But
This was
whether
dated, your lordship, 11/2/2020.
this was with regard to the earlier owner,
Lordship,
with regard to the vehicle. Now the ownership changed, the authorities had changed the name.
lordship,
It says, is the license, second line,
lordship,
English. The license number so and so is sent herewith with duly transferred in your name. Now this expired in March 2026. Have you got it renewed?
lordship, please follow the procedure as laid down so and so
Hmm.
and submit complete documents renewal of license in reserve. Reach
So as
office
to reach
owner
this
before
office
FY
owner
21
before
to
the
avoid
expiry.
late fee. That your lordship, that instruction I don't
Okay,
have right now.
My lord, to help this honorable court, page 199, it might work out to my senior's advantage, my lord. 199, my lord.
Hmm.
The second column, serial number 7. Serial number 6.
6.
Date of replacement of safety valve in operating condition on or before. So I think that might imply that it has, that is just my 2 pence, my lord.
Okay, that will go in.
Yes.
This is just a renewal.
Lord,
He'll get it.
Lord.
Mr. Sharma,
My lord,
all said and done.
my lord.
Mr. Bodhakur, one
Lordship.
query. Now, if you come to the last page of the 214, page 214, last line.
Lordship,
Hence, you are advised not to position the TT at unloading or getting any more loading advice. Is this vehicle being operated now?
yes, your lordship, these were under operation, your lordship.
So this is continued to be operated.
Continue to be operated, your lordship, and therefore, your lordship, even when the last round of litigation was going on, these were under operation, your lordship.
Okay, fine. That was under the
Lord.
earlier tender.
Tender.
Now, when the fresh tender, is this vehicles again being used?
Yes, ma'am.
Yes, yes, sir.
So,
The LOA is, my lord, a contingent document. My lord will kindly come to.
no,
me
I
on
got the
150.
LOA.
My-
We know
my lord.
that LOA is there.
My lord,
This vehicle was with you.
my lord.
The LOA required that he should get the documents within 4 months.
4 months of the issuance of the LOA.
So, at the time of issuance of LOA,
My lord,
he was only having an agreement to say.
agreement to seal, my lord.
This vehicle was to be freed by you because that tender was coming to an end.
My lord.
So, if you had freed it prior to 31/10, 2 months prior to 31/10/2025, he would have, these things would have fitted in. Now, you continued that. And this was not continued with him. This was continued with the earlier owner.
My lord.
So he is the contractor.
Two months.
Now, if he is given an option that I'm giving you 2 months more extension,
2 months.
will anybody deny that?
No, my lord, IOCL in this tender does not have a privity of contract with Mr. Bordoloi, who is a
We-
part of the tender there, my lord.
We are not concerned with the client of Mr. Bodhakur now.
My lord,
You issued an LOA,
my lord,
but the vehicle is with you,
my lord,
right?
my lord.
This is a tender. This is a condition wherein Mr. Bodhakur had applied that an existing vehicle,
My lord.
he will transfer it to his name
True.
and get it operated.
True.
I don't know why those conditions are there, but
True.
that's a condition
My
given.
lord.
Now you knew that the vehicle which Mr. Bhattakur is giving
My-
is with you
Yes,
because the earlier contractor and Mr. Bhattakur had entered into an agreement.
my lord.
That is Form 40 that was given to you.
True, my lord.
Now, when you knew about that, you had never asked Mr. Bhattakur whether you are consenting to have this extension made or not, because your contract may get
Extended.
extended or your contract may be failed. You never approached him. You approached the earlier contractor. Any contractor who gets it, why will he say no?
No, my lord, our actions, my lord, what I must submit.
And one more query
My lord.
before you make your
My lord.
submission. Now say Mr. Bhattakur got that vehicle converted in his name.
True.
At that point of time,
Before the lapse of-
before the extension,
my lord.
right? Would you have permitted that person to continue with that vehicle again?
No.
You would not have permitted him.
So we would not have permitted it. My lord, the reason why you have done what you have done is that the provision of the ATS was a privilege which is granted to the bidders, where the stipulation of the cutoff date, my lord, rarely does it happen that it extends or exceeds the tender date. Now,
Fine.
my lord,
But in a peculiar situation like this,
my lord.
wherein you are also a party to the whole thing,
So we are a party, my lord, but the entity, but this tender is a standalone agreement.
there is no dispute with
My
that.
lord, my lord,
This is a standalone tender.
my lord.
If it was for a vehicle
True.
which was being operated there, say this condition is not there, the corrigendum is not there. He offers a vehicle which he is to buy from an earlier contractor. And this situation develops. We may not come in.
Hmm.
But here, with open eyes, you made an offer that, see, you can give me vehicles
Yes, my lord.
after with an agreement to sale, ATS.
My lord.
And this agreement to sale vehicle is with you.
Yes.
So in this context, the earlier situation will not prevail. Here,
My lord.
you also knew that he cannot do that within that period of 4 months. You gave him 4 months
We gave him 4 months, sir.
because that contract has to end. Then only the vehicle would be free to be sold.
My lord, the ATS provision is not subject to individual tenders and individual requirements because we just give a window period of 4 months that,
Okay, fine.
My lord.
But here you will have to also factor in
my lord,
that this 4 months, 2 months were with you.
it was with me. It was with me by way of a different contractor. Now, it is my humble submission, my lord. It is duty of
Where
the
is
petty-
that agreement to sale, Mr.? Is it on record?
Yes, yes. yes, that's
One-
true.
40, my lord, page 140. Page 140, my lord, the second last paragraph, my lord.
No, that's the condition, your lordship.
Condition, yes.
So the tank which is to be taken
My lord,
has to be a tank which is operated currently
currently,
by any one of the OMCs.
OMCs, my lord.
So that's a requirement?
That's a requirement.
Okay. Then where is the agreement?
Your lordship will kindly come to page 151. That's the affidavit we have. Now, your lordship will kindly note one aspect, your lordship, that 4 month of window period has been given, considering the fact that those are under operation of the respondent authority and it has a particular time period to complete the contract, your lordship.
Mr. Sharma,
My
you
lord.
file your affidavit.
We'll do it, my lord.
In the meantime, you continue with this arrangement that you are continuing.
My lord.
And to that extent, we stay this subject to your the material you bring on record.
Then my lord will also kindly observe one submission, my lord, that the writ petition is not maintainable
Why?
because the impugned order has been passed based on the provisions of the ATS provision of the corrigendum at page 140.
Hmm.
So unless that term is challenged, which is the basis for issuance of the-
Okay, that is a plea which you can take,
My lord.
preliminary objection you can take in your writ
my
petition.
lord, my lord,
But today,
my lord,
with this, at least this court's view is
my lord,
that you had the knowledge
my lord,
that the vehicle which is being put up
my lord.
is either with you or with some other OMC.
Yes, my lord.
Because that is the only category of vehicle which can be
Under
put
the
up.
ATS scheme, my lord.
Now the extension having taken place, how far the petitioner will be prejudiced?
Now, my lord,
That's all.
162, just for a moment, page 162, my lord.
Mm.
Page 162,
Mm.
point number 5. So it was in the control of the contractor with whom the petitioner has entered into an agreement. Now that contractor in that tender had agreed to extend it. Now,
Naturally,
had
he
the
gets 2 more months of income. Why will he let it go?
my lord, that is an absolutely true fact, my lord. He should not idly let it go. But the IOCL is also bound by the terms of its own tender, where we have not diverted or deviated from our own terms, my lord. We have acted within the parameters of the tender document. No legal or fundamental right of the petitioner has been.
We are not on that. We are only on the question
My lord.
whether the extension sought for by the petitioner is to be given a very strict interpretation, or considering the facts
My lord.
involved,
My lord.
it has to be looked into. These are the issues. He will say, please look into the issues, and for his support, he will rely on the earlier observations of the coordinate bench.
My lord.
You will say, tender conditions are tender conditions.
My lord.
It cannot be diluted. We'll hear it. We'll hear it. And see, this letter,
My
the
lord.
petitioner is nowhere involved. Although you knew that this vehicle is also one of the vehicles given to you.
But under this tender, the current tender under tender rated 1/3/2025, we do not have knowledge of individual or customized extension of different tenders. We have only merely stated that
No,
a TT.
when you are the authority,
My lord.
this vehicle
My lord.
is also marked in his name in the fresh tender.
It is
Same authority.
he had LOA. The LOA was issued in terms of 4 vehicles. In
LOA was issued on.
16/9, my lord. 16/9/2025.
So that is after the extension was given.
No. Yes, that is
Yes,
after the extension was given. But that is also how the petitioner had willingly walked into the condition, knowing that the LOA being contingent upon the 4-month period, he'll not be able to fulfill that. So when the LOA was issued, the petitioner was also in the know that the TT that he has provided under the tender would not be made available within the
So
stipulated
your
parameters.
that action of extension of the contract, although you knew that you have floated a fresh tender for the same very work. It's the same very work.
My lord.
The work is the same.
Transportation, my lord.
Transportation, the areas of under which it is being transported is also the same. These transporters would be the same. I have replaced by way of a new contract. That's the thing.
True.
So there is no difference here. It's a continuing contract, but with different contracts being executed.
The idea to have the ATS agreement in the tender is that it already gives a veracity of the tank trucks which are plying under separate contracts with the OMCs, not specifically IOCL, and which renders that slightly authentic and reliable in the scheme of things.
We got it. We got it. Once that is because you wanted to have some surety that the 10 truck which is being given,
yes, my lord,
at least under ATS, are trucks which have already been proven to be worthwhile in transporting materials.
And that's where you stop, my lord.
That's it. But once you have come to that conclusion, and you yourself have extended a tender, you cannot frustrate his right.
My lord, the legal entity
and
in a larger head would be the same, my lord. But
you extended it for 2 months. So the tender was that it will come to an end at a particular date.
True.
So you should have done all these things.
My lord.
Say in August, it should have come to an end. Then given him 4 months.
True.
Vehicle was free. He could have done it. But you could have run the 2 months period on ad hoc basis. On ad hoc. Say ad hoc 2 months we do it. Now you extend it for 2 months. Then within that extension of 2 months, you issue an LOA to him. That vehicle is already marked with you for 2 months.
So the LOA is a provisional document based on the documents and the...
So why this LOA was not issued in August or before August?
So the LOAs were issued in the month of September for
or before your extension, if the LOA was issued.
My lord.
Again, you could have and argued that now we have issued that you did not take the vehicle, so we are not bothered, we will not give you. Now, you issue the LOA after the extension. So he has to just wait and watch for a month more. Thereafter, he can take steps. Because once he starts taking steps, the vehicle will get transferred to him.
True. My lord, here what has happened is that the petitioner, by way of his contractor friend with the other tender, has sought to get the benefits of both the terms of the tender, where by violating the
Oh,
terms of the
we'll
new tender,
consider that.
because the
We'll
4-month period has not been adhered to. We have,
We'll consider.
and your lordship will kindly record the maintainability plea, my lord.
Hmm?
The maintainability plea also. My,
No,
my-
that I'll keep it
my
open,
lord.
don't worry.
my lord.
But Mr. S.K. Bhattakur, learned senior counsel, assisted by Mr.
This weekend.
Huh? By Ms. J. Soikia and Mr. U. Bora, learned counsels appearing for the petitioners. I have more than two also, no problem. Also heard Mr. S.S. Roy, learned PGC appearing, learned PGC, as well as Mr. M. Sharma, learned standing counsel for Indian Oil Corporation.
2, 3, 4, 5, 6 months.
All 4, 5, 6, 2, 3, 4, 5, 6.
My lord, 2, 3, 4, 5, 6 months.
Also, issue notice. Mr. S.S. Roy, learned CGC accepts notice on behalf of respondent number 1, while Mr. M. Sharma, learned standing counsel, Indian Oil Corporation, accepts notice on behalf of respondent number 2, 3, 4, 5, and 6. No fresh notice is to be issued. Huh? The petitioner has prayed for an interim direction. The learned counsel for the parties were heard. Also, the challenge in the present writ petition is to a picking order dated 5/5/2026 passed by the respondent number 1 corporation, rejecting the claim of the petitioner for operating the tank trucks which were awarded to him by issuance of a LOA dated. LOA is dated
16/9/2025, my lord.
16/9/2025 on the ground that the petitioner could not submit documents envisaging transfer of the vehicles in his name within the time frame as mandated in the letter of acceptance bracket LOA. Also, the petitioner had submitted his bids for being awarded the contract of transportation of petrol and petroleum products in pursuance to the NIT notice inviting tender dated
1/3/2025, my lord.
1/3/2025, read with the corrigendum dated
4/4, my lord.
4/4/2025.
2025.
Also, in pursuance to the bidding process, the petitioner was issued. Where is that LOA page?
My lord, it starts at page 153, my lord.
52
53, my lord.
153.
was issued with an LOA dated 16/9/2025, awarding to him
The truck side, page 157, my lord. 157. 4 trucks, my lord.
which are the ones?
My lord, the second one, third one, and fourth one, my lord. Ending with 5633, 0447, and 0448. Those have
157.
157, my lord.
Okay. Awarding to him 4 trucks, allotting to him 4 trucks for transportation of the petroleum products. Also, the trucks involved were submitted, were submitted by the petitioner in the bidding process after having entered into an agreement for sale with the owner of the said trucks in terms of the provisions made in the corrigendum dated 4/4/2025. Also, the LOA had required the petitioner to submit the requisite documents envisaging the transfer of the said trucks in his name within a period of 4 months from the date of issuance of the same. Also, before the LOA could be issued to the petitioners, it is to be noted here that the 4 trucks which were earmarked in respect of the petitioner in the LOA were already being operated by the earlier owner of the trucks in a similar contract with the respondent number 1 corporation. Also, the said contract was to come to an end. Where is that document? Extension 150?
Your Lordship, 153 is.
161, my lord.
Was to come to an end on 31/8/2025. However, while an order dated 16/8/2025, the said contract was extended for a further period of 2 months, and the owner of the trucks in question had accepted the said extension and continued to operate the trucks under the respondent number 1 corporation in terms of the earlier tender process. Also, the petitioner projects that on account of the said extension being effected, there was a delay in getting the trucks freed for the purpose of transferring the ownership of the same in the name of the petitioner herein. Also, the petitioner, the trucks in question, the ownership of the trucks in question were after the due process, after completion of the due process involved, were transferred in the name of the petitioner by issuing of a fresh RC in this connection on 2/2/2026. All are 2/2/2026.
Dates are slightly
26.
Slightly different.
7/2 also, my lord. There are
2/2/2026/7/2/2026. Full stop. It is also projected that the PESO license in respect of the said trucks, which were already granted, was also converted in the name of the petitioner herein, by the competent authority, a communication dated 11/2/2026.
And it is renewed also, Your Lordship.
Full stop. And the same is projected to have been renewed thereafter. Full stop. The petitioner not having submitted the requisite documents within the time frame prescribed in the LOA, a show cause notice came to be issued to the petitioner on
5/3.
5/3/2026. Also, the petitioner submitted his reply thereto on 7/3/2026. Also, the petitioner apprehending adverse action on the part of the respondent number 1 corporation, approached this court by way of instituting a writ petition being WPC number 1514/2026. A coordinate bench of this court, while order dated 13/3/2026, was pleased to dispose of the said writ petition by directing the respondent number 1, the authorities of the respondent number 1 corporation to consider the representation, so-called reply submitted by the petitioner herein. Also, the interest of the petitioner was also protected by providing that the respondent authority shall not enter into any alternative arrangement with regard insofar as it concerns the vehicles allotted to the petitioner till the returnable date. This is continuing. This
Lord,
petition is pending.
No,
Full stop.
Now, that writ petitions were disposed of.
Disposed of, my
We
lord.
have withdrawn after passing of this
Okay.
order.
It is to be noted that the said writ petitions were subsequent, full stop. Thereafter, the petitioner's representation was taken up for consideration. Full stop. The operative portion of the order dated 13/3/2026 being relevant is extracted here in below. Para 12, 13. Page 179. So, the representation, the show cause reply submitted by the petitioner was in terms of the directions passed by this court, why the said order dated so and so, considered by the respondent authorities, and why a speaking order dated 5/5/2026, the claim made by the petitioner in his show cause reply was rejected. Also, this court, why the order dated so and so, having required the respondent authorities to specifically examine the claim of the petitioner by considering the reasons assigned by him for the delay occasioning in submission of the documents as mandated by the letter of by the LOA. It is found that why the speaking order dated 5/5/2025, the said aspect of the matter is not found to have been so considered. Also, the learned counsel for the petitioner has submitted that the change of ownership of the vehicle in question was not permissible till 31/10/2025, inasmuch as the vehicle was being operated by the earlier owner in a contract which was extended till 31/10/2025. The contract being entered, being performed under the respondent number 1 corporation itself. Also, he submits that after the vehicle was so freed from the said contract, the requisite steps were taken and expeditiously the follow-up steps for change of name of the ownership of the vehicle as well as in the license, PESO license, PESCO license, were all completed. Mr. M. Sharma, learned counsel, standing counsel, Indian Oil Corporation, disputes the said position and submits that the LOA having mandated a particular time frame, it was not open for the respondents. It is not open to the petitioners to complain with regard to the set time frame prescribed after having defaulted to have submitted the requisite documents within the time frame so specified. It is submitted that the time frame having been specified in terms of the tender conditions, it is not open for the petitioner to assail, to question the same without assailing the conditions in this connection existing in the tender read with the corrigendum dated 14/4/2025. Also, I've heard the learned counsel for the parties and peruse the
One additional submission. After the LOA, successive work orders were also issued to other bidders. So the work order has not also been issued here, which does not give a vested right to the petitioner. That is also
Mr. Sharma further submits that although an LOA has been issued, the default occasioning on the part of the petitioner had resulted in work orders not being issued to him.
My lord.
Accordingly, a contract in the matter cannot be said to have been formed. Accordingly, no right exists for the petitioner to question the steps taken by the respondent corporation, including the contentions raised in the speaking order dated 5/5/2026. I have heard the learned counsel for the parties and also peruse the materials available on record. This court on a perusal of the materials is of the prima facie view that on account of the extension of the contract beyond the earlier contract beyond the period that is 31/8/2025 being effected while the order dated 16/8/2025, the vehicle in question being involved in the said contract, cannot be said to have been freed for the purpose of its transfer in accordance with the agreement of sale executed, comma, in the name of the petitioner. This court also finds that the letter of award was issued to the petitioner after the extension was effected of the earlier contract. Moreover, this court in the earlier round of litigation having required the respondent authorities to specifically consider the claim, the contentions raised by the petitioner in his show cause reply towards justifying the delay occasioning in continuing in complying with the conditions set out in the letter of acceptance, comma, this court finds that the said issue was not considered by the respondent authorities while passing the speaking order dated 5/5/2026. However, these conclusions drawn by this court at this stage is only for the purpose of consideration of the interim prayer, and the same would not be a final, and the same accordingly is a tentative one. This court further finds from the impugned order dated 5/5/2026 that the vehicles which are being projected in respect of the petitioner herein are being utilized by the respondent corporation for transportation of the petroleum products, and it is only by the speaking order that the petitioner has been restricted from carrying out operations, carrying out transportation of petroleum products by the vehicles in question. So, accordingly, this court is of the considered view that interim direction it be called to be passed in the matter in the facts and circumstances noticed herein above. Accordingly, it is directed that till the next returnable date, the impugned order dated 5/5/2026 shall remain suspended. The petitioner, vehicles of the petitioner being utilized, be continued to be utilized for transportation of petroleum products till the next date of listing. However, it is made clear that this interim direction would not confer any right upon the petitioner to claim that the contract has been executed with him. The said aspect of the matter would be considered by this court after the respondents have brought on record their stand by way of filing their counter. At this stage, Mr. Sharma, by pointing out to the tender conditions as well as by highlighting the fact that the petitioner has not assailed the tender condition, has prayed that the maintainability of the present writ petition, question of maintainability of the present writ petition be kept open. The prayer is considered and it is directed that the question of maintainability of the present writ petition shall be kept open, provided it will be open to the respondents to raise such plea in the affidavit to be so filed by them.
One correction, madam. The TTs, the tank trucks, were suspended in the month of March pursuant to the issuance of the show cause.
But here it says you're continuing.
No, 169, my lord. If your lordship sees page 169. There might be some small, I'm submitting this on behalf of the corporation, my lord. The TTs have been put on suspension from the month of March itself. 169, my lord. The third last paragraph.
It will interim order to it will to cut. Okay, we will not.
Lordship, our TTs were not being run
No.
since.
No. That's why I asked you.
Lordship, I have taken the instruction.
Okay.
It was used
Law
in
to
the show cause.
that's a misnomer in your that speaking order.
And my lord, in the scheme of things, my lord, work orders have been issued.
Okay, fine.
Subsequently,
We
my
will
lord,
say.
will status quo, my lord, will grant a status quo to the petitioners if not utilized already, because there's a possibility of it being allotted.
Call for to. So accordingly, it is directed in the facts and circumstances of the matter that till the next returnable date, the respondent authorities shall not enter into any alternative arrangement as against the 3 tanker trucks placed by the petitioner. So it is also provided that if it is so necessitated, The respondent authorities are at liberty
My lord.
to utilize the tanker trucks
True,
of
lord.
the petitioner. However, such utilization would be without prejudice to the rights of either of the
Lord.
parties.
Status quo.
P of maintainability.
I'm grateful, my lord.
Second one is fine.
Only one truck.
Only once.
Second is only one truck.
One.
The
I'll do
yellow-
that. Once she types this,
My lord, my lord.
In the present one, 3 trucks, you're
and they're in one.
deeply obliged.
And you should not be feeding Mr. Bhattakur now like before. Give him all the information at one go. You get my point? Now Mr. Bhattakur earlier used to get all the information. Now he can't. You will have to feed him. And everything will not be in one capsule, not in small pills.
Deeply obliged. And your lordship, S. Bhattakur, not SK.
Oh, yes, Bhattakur. Yes, Bhattakur. Yes, Bhattakur. Yes, Bhattakur. Not senior counsel.
Your Lordship,
Yeah, yes.
I come back according.
Yes, yes.
Your Lordship, according to my senior's instruction, the petitioner is a CRPF commandant, and there has been 4 charges against him. Two by the IO, 2 has been proved and 2 has been disproved. And also the same has been forwarded to the UPC, and the UPC has remanded back the letter while showing disagreement. The If
Okay,
the petitioner-
that much is enough. More parun with 3 bench 3 to parim. No, no. See, I'm told that this is a bench 3 matter. It bench 2. CRPF, no? CRPF is bench 2. 3. You will have to mention before the senior court.
Yeah.
This bench 4 I am having, bench 3 I'm not having. And next time, more preparation than this. You appear, I'm notary. Appear before me, I'll not give you adjournment until you tell me the full facts.
Your Lordship.
It's again under apology, Lordship. In item number 34 to 36, Lordship, if I allowed a adjournment, but in item number 36, is it not connected with the item number?
No, I'm only, 34, 35, 36, okay.
Yes, so my phrase is appear for the 36.
34 and 35.
Lordship, for the 36, Lordship, this matter is wrongly connected, tagged with Lordship.
Okay, let it be there, we'll see. 34, 35, more to order pass. 34, 35, 36, tag it is submitted at that item number 36 has been wrongly tagged with item number 34 and 35. Accordingly, registry to detag item number 36 from item number 34 and 35. Item number 34 and 35 on the prayer made on behalf of Mr. P.D. Nair, learned counsel for the petitioner, be listed after 2 weeks. So, item number 36, you are appearing.
Yes, Lordship, but we want to take the matter, Lordship. We want to
It will be there.
when the matter calls.
It will be
There is an interim order, it is my point.
the 34, 35 interim order passed earlier to continue till the next date of listing.
Problem is highly.
36 to Thaki Bode. Itu mati batami. Yeah. Who was it? Let's talk. But Mr. Had Dr. P.K. Goswami, learned counsel for the petitioner. Also heard Ms. D. Bora, learned standing counsel, Health and Family Welfare Department, appearing for the respondent number 1 and 2. Also heard Mr. S. Dr. learned counsel, learned counsel, appearing for the respondent number 3 to 9. Ms. D.L. Decca, learned counsel, appearing for the respondents number 10, 11, 12, 14, 16, 17, 18, 19, 20, 21, 26, 27, 29, 30, 31, 32, 34, and 35. You are appearing for?
For on behalf of MS D Barua.
Okay. So, is a 35 mazor. None appears for respondent number 8. So, the matter was heard on 26/5/2026 and was directed to be listed today for passing of orders. So, you can take yours. Anything to say?
No, but
Please. The petitioner in the present writ petition has prayed for, has assailed an order dated 29/12/2016 passed by the Director issued by the Director Health Services Assam, comma,
Is it here?
29/12/2016, rejecting the claim of the petitioner for promotion to the post of UDA in the establishment of the Director of Health Services. So, the petitioner has also assailed a gradation list. I know. I think it's correct issues again. Gradation list dated 12/3/2015 of the petitioner has also assailed the seniority position assigned to her at serial number 45 in a gradation list issued on 12/3/2025 of the incumbents in the cadre of
2015, my lord.
2015 of the incumbents in the cadre of LDA/junior assistant in the Directorate of Health Services, Assam. Also, the facts requisite for adjudication of the issues arising in the present writ petition is noticed as under. The husband of the petitioner, Dr. G.K. Das, while serving as a deputy superintendent of Bongaigaon 30-bedded hospital, was killed by some unknown miscreants. Also, pursuant to the death of her husband, the petitioner had applied for consideration of a case for appointment on compassionate grounds. Also, the respondent authorities, on consideration of the case of the petitioner, proceeded to appoint her on compassionate grounds. Wide issuance of an respondents on consideration of the case of the petitioner proceeded wide order dated 24/10/1997 to appoint her as an LDA against a vacant post at Golaghat under the administrative control of the Joint Director of Health Services, Golaghat, Assam, on compassionate grounds. Also, the said place of posting of the petitioner having caused inconvenience to her, the petitioner had approached the government for a suitable posting in her, for consideration of her case for a suitable posting in Gauhati, preferably in the Directorate of Health Services, Assam. The said application is seen to have been placed before the Chief Secretary of the state, who had then desired that the appointment of the petitioner be modified and she be appointed against a vacant post in the establishment of the Director of Health Services, Assam. The said aspect of the matter was communicated to the Director, Health Services, Assam by the Deputy Secretary to the Government of Assam, personnel (B) department, wide a communication dated 11/11/1997. Also, in pursuance to the said communication, the Director of Health Services, Assam, proceeded wide an order dated 5/12/1997 to direct the petitioner to join the Directorate on attachment basis until further order, and she, on her such joining, was to be placed in the statistics branch of the directorate. So thereafter, the petitioner was transferred by an order dated 15/3/1999 from the establishment was transferred and posted to the establishment of the government analyst, state drugs testing laboratory. So, the petitioner at this juncture had approached this court by way of institution of a writ petition being WPC number 7556/2003. Also, this court, a coordinate bench of this court, wide order dated
21.
that order is on record. In your reply, you have got it.
Order dated 18/9/2003.
My Lord Justice Bishwas's order.
If my lord.
It's on record somewhere, I saw it. I lost my note. That was the problem. WPC number 112. Wide order dated 18/9/2003 as an interim measure had directed the respondent authorities to comply with the directions passed by the government pertaining to the posting of the petitioner hearing. Also, accordingly, wide an order dated 5/12/2003, the petitioner was transferred and posted from the establishment of the government analyst regional drugs testing laboratory Gauhati to the establishment of the additional director health services rural Assam. Also, in the same capacity. Also, the petitioner complied with the said order of transfer. Also, thereafter, it is seen that there were further directions from the government with regard to the posting of the petitioner in the Directorate of Health Services. Also, accordingly, wide order dated 9/6/2010, the Director of Health Services, Assam, proceeded to transfer and post the petitioner to the establishment to his establishment as a junior assistant against a vacant post arising on account of the incumbent therein being promoted to the post of senior assistant. So, it is to be noted that in the said order dated 9/6/2010, the pay of the petitioner was directed to be fixed in terms of the provisions of FR 22(1)(a)(2) with effect from the date of her joining as junior assistant in the establishment of the directorate. So, the petitioner accordingly, in terms of the said order, joined the directorate on 1/7/2010 as against the post of junior assistant and continued to discharge her duties therein. So, the petitioner, having acquired the eligibility criteria for upgradation or for grant of financial upgradation under the Assured Career Progression Scheme of the said state government, the petitioner was wide order dated 19/11/2014 granted her first financial upgradation with effect from 1/1/2011. It is to be noted that for the purpose of the said upgradation, the date of initial appointment of the petitioner, that is 8/12/1997, was so reckoned. Also, the respondent authorities thereafter published a gradation list of the incumbents in the cadre of LDA of the Directorate of Health Services, Assam, and therein the petitioner was placed at serial number 45 by reckoning the date of joining by her in the directorate. Also, the petitioner being aggrieved by the denial to her of her due promotion to the cadre of senior assistant, as well as her placement in the said grade seniority list, the petitioner approached this court again by way of instituting a writ petition being WPC number 1721/2014. A coordinate bench of this court, while order dated 18/11/2016, proceeded to dispose of the said writ petition, directing the state respondents to consider the case of the petitioner for promotion to the post of upper division assistant in the event strictly upper division assistant, strictly in terms of the provisions of Rule 9 of the Assam Services Manual. No, pension services. 882. Assam Directorate Establishment, bracket ministerial, bracket over Service Rules 1973. So in the alternative, this court had also directed that the state respondents may also consider giving financial upgradation to the petitioner under the SEPS scheme. So it is thereafter that the Director of Health Services, Assam, proceeded to issue a speaking order dated 29/12/2016, rejecting the claim of the petitioner for her promotion, for consideration of a case for promotion to the rank of senior assistant in the directorate. Also, being aggrieved, the petitioner has instituted the present writ petition. Dr. P.K. Goswami, learned counsel for the petitioner, after reiterating the facts noticed herein above, 3.1, 3.2, has made the following submissions. 1. The petitioner, although appointed on compassionate grounds at Golaghar, by the order dated 25/10/1997, the government had required such modification of such posting of the petitioner, and for her posting at the posting against a vacant post in the establishment of the Director of Health Services, Assam. Mr. Goswami submits that although such directions were passed, which were binding on the Director of Health Services, Assam, the said authority, however, did not consider the posting of the petitioner in the directorate. However, she was initially only attached against the said post. It is submitted by that the petitioner, with effect from 5/12/1997, is working as against the post of LDA in the directorate till she was transferred and posted to the establishment of the State Drugs Testing Laboratory, by the order dated 15/3/1999. Also, This court, Mr. Goswami, by referring to the directions passed by this court while the order dated 18/9/2003 in WPC number 755/2003, submits that the set direction was to the effect of posting the petitioner in the directorate. However, the Director of Health Services, Assam, in violation of the said directions, proceeded to transfer and post the petitioner to the establishment of the additional Director Health Services bracket rural, Narangi, and again attach the services of the petitioner with in the Directorate of Health Services. So accordingly, it is submitted that the petitioner, with effect from 5/12/2003, although was transferred and posted to the establishment of the additional Director of Health Services, Narangi, in fact, in reality, she continued to discharge her duties in the directorate. Right, Mr. Goswami?
More point is there, my friend. No, the undersecretary himself admitted that that attachment order was illegal.
I'll come to that. I'll come to that. So, accordingly, it is submitted that the Director of Health Services, for reasons not known, had only with the view to cause prejudice to the petitioner, had violated the express directions passed with regard to the posting of the petitioner by the government. It is also submitted by Mr. Goswami that, by Dr. Goswami, that the government had also held that the posting of the petitioner on attachment with the Directorate of Health Services Assam was a illegal one. White communication dated
4/7/2002.
4/7/2002.
And except 5 May.
Accordingly, Dr. Goswami submits that with effect from
5/2/97.
5 to first order was 5/12/1997. The petitioner is to be reckoned to be an incumbent in the cadre of LDA in the establishment of the Director of Health Services, and accordingly her seniority therein is to be so reckoned. Mr. Goswami has also ably made a submission to the effect that the order dated 9/6/2010 transferring and posting the petitioner to against a post of LDA in the directorate, having been so issued without any stipulation of the petitioner losing her seniority and or requiring the petitioner to join to occupy the bottom seniority, the seniority of the petitioner on her joining on a regular basis in the establishment of the Director of Health Services Assam is to be so reckoned from the date of her initial appointment, that is 11/11/1997, and or with effect from the first attachment made in her case, first attachment of her services made in the Directorate of Health Services wide, the order dated 5/12/1997. That is your case, Mr. Oso. Accordingly, Mr. Goswami, by taking this court through the speaking order dated, by referring to the speaking order dated 29/12/2016, has submitted that the Director of Health Services Assam had not appreciated the contentions raised by the petitioner, as well as the observations made by the coordinate bench of this court, quite the order dated 18/11/2016 in WPC number 1721/2014, and accordingly, the speaking order dated 29/12/2016 would mandate an interference from this court. In the above premises, Dr. Goswami submits that appropriate directions be issued towards promoting the petitioner directions be issued to the respondent authorities to consider the seniority of the petitioner in the cadre of LDA in the establishment of the Director of Health Services Assam by assigning to her seniority position in the said cadre by reckoning the first date of her attachment in the directorate against the post of LDA effected by the order dated 5/12/1997. It is further prayed that on such assignment of seniority being done, the petitioner be promoted to the cadre of UDA with retrospective effect, that is, with effect from the date persons joining after 5/12/1997 were so considered and promoted to the post of UDA with all consequential benefits. Mr. Goswami has submitted that the petitioner had superannuated from her services with effect from (31/12/2016). Per contra, Ms. M.S. D. Bora, Learned Counsel, Learned Standing Counsel, Health and Family Welfare Department. Submits that the services of the petitioner was required to be the full stop. It is submitted that in Bora submits that on account of non-availability of a vacant post in the cadre of LDA, the petitioner, while order dated 5/12/1997 was required to be brought to the directorate on attachment basis. It is submitted that the petitioner during the period of her attachment had drawn her salaries from the post against which she was originally appointed in Golaghat. It is submitted that after the various transfer and postings effected in respect of the petitioner, she was finally, by the order dated 5/12/2003, brought to the services of the directorate against a vacant post of LDA now becoming available in the establishment. It is submitted that prior to the said transfer and posting of the petitioner was serving in the district establishment, which is separate and distinct from the establishment of the Directorate of Health and Family Welfare. It is submitted that the seniority of the incumbents in the district establishments are not maintained along with the incumbents in the post of LDA in the Directorate of Health and Family Welfare, and separate seniority lists are maintained for the said two distinct and separate cadres. It is submitted that the petitioner, having joined on regular basis in the establishment of the establishment of the Director of Health Services Assam only in pursuance to the passing of the order dated 9/6/2010. Order dated, she was brought over 9/6/2000. Only on passing of the order dated 9/6/2010, and the petitioner having joined her services with effect from 1/7/2010, the petitioner cannot be assigned seniority position over the LDAs already working in the cadre in the establishment of the Director of Health Services Assam as on 1/7/2010. Accordingly, Ms. Bora submits that the seniority position assigned to the petitioner by reckoning her date of joining in the direct services of the Directorate would not mandate an interference by this court. So, Ms. Bora Pada submits that the prayer of the petitioner for promotion was duly considered by the Director of Health Services Assam wide the speaking order dated 29/12/2016 and had proceeded to reject her such claim only on the ground that the seniority position of the petitioner did not bring her within the zone of consideration for being considered for such promotion to the post of senior assistant. So, anything more, Ms. Bora? Madam Bora, anything more? Anything more?
No, Lordship.
So, in the above premises, Ms. Bora submits that the claim made by the petitioner, and that too after her superannuation from her services, a claim made by the petitioner in the present proceedings, which admittedly was instituted after she had superannuated from her services on 31/12/2016, would not mandate acceptance by this court. The learned counsels appearing for the respondents number for the private respondents have adopted the submissions made by Ms. D. Bora and submit that you are all promoted as UDS now, and that they were promoted to the cadre of upper division senior assistant in the establishment of the Director of Health Services, basing on the seniority position assigned to them in the cadre of junior assistant in the directorate, as well as after having acquired the requisite qualifications for being considered for such promotion. It is submitted that the petitioner, having joined in the directorate after the joining of the private respondents herein, she cannot be held to be senior to any of the private respondents, and accordingly the claim of the petitioner for being considered of being deprived of a due promotion to the cadre of senior assistant during her service tenure would not mandate an acceptance from this court. Anything more? Also, I've heard the learned counsel for the parties and also peruse the materials available on record. The facts noticed herein above are not in dispute. It is also not disputed that the petitioner for the first time was posted on regular basis in the Directorate of Health and Health Services Assam wide the order dated 9/6/2010. The petitioner, in pursuance to the said order, had joined her services as a LDA in the establishment of the Director of Health Service as a junior assistant in the establishment of the Directorate of Health Services on 1/7/2010. Also, basing on the date of joining of the petitioner was assigned seniority position at serial number 45 in the gradation list subsequently issued of the incumbents in the cadre of junior assistant in the directorate. Also, it is seen that the petitioner, being aggrieved by the seniority position assigned to her, as well as the denial to her of a due promotion to the cadre of senior assistant, had approached this court by way of instituting a writ petition being WPC number 1721/2014. A coordinate bench of this court, while order dated 18/11/2016, gave a final consideration to the said writ petition and basing on the materials coming on record, had drawn the following conclusion. Page 43A. Drawn the following conclusion. Following conclusions will appear. A to A. A perusal of the said conclusions would go to reveal that the court had noticed that the petitioner was included in the gradation list by reckoning that she had joined the services of the directorate with effect from 1/7/2010. So, the date of joining of the petitioner in the gradation list not being disputed, the said issue was not gone into. So, this court thereafter, by noticing that even if the petitioner was held to have joined the directorate, services of the directorate with effect from 1/7/2010, she had acquired the requisite eligibility criteria for being considered for promotion to the cadre of upper division, cadre of senior assistant. However, subject to the her seniority position in the gradation list. Also, having drawn the said conclusion, the coordinate bench further proceeded to hold that the case of the petitioner is that the petitioner is entitled to a consideration for promotion to the post of upper division assistant, having regard to the provisions of Rule 9 of the Rules of 1973, and accordingly, it was directed that an exercise be taken for considering the case of the petitioner strictly by following the provisions of Rule 9 of the Service Rules of 1973, along with other eligible candidates. This court further provided that the direction for undertaking the exercise, however, be subject to any vacancy being available in the post of senior assistant. Thus, the coordinate bench further held that in the alternative, the state respondents may also consider giving financial upgradation to the petitioner under the SCPS scheme. A perusal of the set of the conclusions drawn by this court in the earlier round of litigation would go to reveal that the seniority position of the petitioner in the cadre of LDA was upheld, and the same was not in any manner disturbed by the court. Accordingly, the seniority of the petitioner in the directorate in the cadre of seniority of the petitioner in the cadre of junior assistant in the establishment of the Directorate of Health Services would have to be held to be so reckonable only from 1/7/2010 and not from a date prior thereto. Also, considering the seniority of the petitioner with effect from 1/7/2010, the petitioner is not found to have come during her service tenure within the zone of consideration for promotion to the post of senior assistant. Also, given the vacant post of senior assistant available in the directorate. So, accordingly, on a perusal of the speaking order dated 29/12/2016, and this court finds that the Director of Health Services Assam had rejected the claim of the petitioner only on the said ground. The operative portion of the said order speaking order dated 29/12/2016 being relevant is extracted herein below. Page 48 B2B. So, the order further brings on record that the petitioner was given one financial upgradation while order dated 19/11/2014 and no further, and given the service length of the petitioner, she was not entitled to the second financial upgradation. This court has minutely perused the conclusions drawn by the Director of Health Services in the order dated 29/12/2016 and finds that the said conclusions are in tune with the observations made by this court while the order dated 18/11/2016 in WPC number 1721/2014. And accordingly, this court is of the considered view that the said that the speaking order dated 29/12/2016, in view of the attending facts and circumstances involved, would not mandate an interference from this court. Also, having drawn the said conclusion, this court would also like to observe that the present writ petition was filed, that the petitioner had superannuated from her services with effect from 31/12/2016, and the present writ petition was filed only on 10/7/2017. Also, it is a settled position of law that after retirement, a claim for a retrospective promotion with effect from a date when the employee was in service is not permissible. Also, the said position permissible in as much as the employee concerned on such promotion being effected in his or her respect would not be in a position to assume the charge of the post of the promotional post. Also, the said aspect of the matter was clarified by the Honorable Supreme Court in its decision in the case of Government of West Bengal and others versus Dr. Amal Satpathy and others, reported in 2024 SSC Online, SC 3512. The relevant observation, the relevant paras of the said paras relevant to the issue arising in the present petition in the said decision is extracted herein below. Para 19, 20, 20. So, accordingly, in view of the decision of the Honorable Supreme Court in the case of Dr. Amal Satpathy, Supra, the claim of the petitioner for a retrospective promotion in her case would also not be mandated to be accepted. Also, for the foregoing reasons, this court is of the considered view that the claims made by the petitioner in the present petition having been found to be not maintainable, the writ petition is held to be devoid of any merit, and accordingly the same stands dismissed. However, there would be no order as to this. Sorry, Dr. Goswami, can't help it. There is an IA, na? IA is in this person. Any private respondent coming? Mr. N. Upadhyay is there.
No, last occasion,
I just want them because if I go against them, they should not be
Only thing, Lordship, on the last occasion, they appeared and they told that they are.
They
not-
said that, something they said,
Yes, they said that they are not appearing.
or they are not appearing. Okay. But Mr. Sharma,
Yes, Lordship.
we have gone through the matter meticulously. Now, 3 points. With regard to that constitution, not very sanguine. Next is whether she was 40. You say from 74, the date of birth, but in the school documents, I find 74 and 79, 2 dates. No clarity. If it is 74, she is within the age. If it is 79, she is not within the age. Now, the third one is the persecution by her of MA, be it without permission. This court in Tonkeshwar Nath has already held that this will be not. Now, the fourth point, on that day which weighed with me when you had projected that, the fourth point was that she has projected that she had undergone MA in 1999 from Dibrugarh University in education.
Yes.
Right? You made a RTI. You or somebody made an RTI before the registrar.
Yes.
Register Dibrugarh University or SPIO Dibrugarh University seeking information whether a lady by this name had undergone that course. And the reply was that we have no lady with that name gone. So at that point of time, she may not be married. She may have another name. 1. 2, you had before that the roll number of the petitioner, the mark sheet of the petitioner, of the respondent number 8. But you never forwarded this to the Dibrugarh University for verification. Why?
That answer is not with me because it was done by somebody else.
Be that as it may, it is on your record in your additional affidavit. If that was there,
It was received on 24. Lordship.
it latest, and these are not issues which were raised before the commissioner. Right? And these are not issues which were raised in the writ petition while seeking a writ of quo warranto. The writ of quo warranto is only on the ground that the committee was not constituted in the manner required. One of the parent members, although was present, had not signed. In this narrow compass, I don't think so. It's a case for interference. She is now retired.
Oh,
She might 74. No. Let her continue. I'll pass the order in the second half.
one thing, Lordship.
Hmm?
28. I made some further study in the second approach.
Second half. So I can't now. I dictated one now. I can't. I'll do it in the second half. 2 o'clock we'll do it.
Yes, Lord.
Obliged.
Lords.
You're getting family pension?
Yes, well, but it's reducing, my lords.
Actually,
It's reducing. I have 3 to 4 children. And the other part, my lord, I read
is
the
the
file.
government responsible for that?
No, my lord. I read the file through one. I read the file many times, my lord. Another approach I wanted to harp on, my lords, the proportionality of the punishment, my lords. Since the respondents themselves had the materials with them, I also had
Never highlighted. And atrophy,
thinking of
to what extent?
Right.
Initial thing that is nothing. It's just mine, yours will differ. I'll have more, some atrophy than you because of the age. A kid would have lesser. Person joining the profession today compared to me will have more brain cells. Mine would have wasted a bit. For good reason, bad reason, that's a different thing. But
that
it would have wasted
I
a bit.
won't comment, my lords. But
So
my
that
case is
by itself will not.
my case is, my lord, if they want to dismiss me, they invoke that principle, my lord, preponderance of probability. That very, if they get slide this,
It's the question is whether your unauthorized absent has been properly explained by you with specific reason. If yes, that's the end of the matter. If no, the punishment has to be upheld.
in that case, man, I'll rely on the judgment, my lords, because admittedly, I cannot go beyond the records. Records
Which is the
reveal, my
one,
lord.
which is the
My lord, this is Mukul Kumar Chaudhary. Chairman,
Pushon Kumar, you are giving up.
Mukul Kumar Chaudhary.
Pushon, you are giving up.
No, that I'll press.
That has been subsequently clarified by
Right.
the Supreme Court in Chennai Metropolitan Water
My lord.
and Sewage Supply
This
to
is
be
Permar-
in the facts of that case.
the Permar, my lord. Well, these case, however, suits my
Our High Court,
lord.
Supreme Court,
No, my Supreme Court.
full zone.
Mukul Kumar Chaudhary. This has some bearing, my lord, so that this person was absent for a period, then he accepts. No.
What is the period of your absence?
It's from 4/7/2013 to my lord, 10/3/2015.
Nearly 4 years.
Oh, no, I'm sorry, but it's 14. Yes, 3/6/2014 to 10/3/2015, because warrant of arrest was issued, my lord, and police brought him back to the unit, my lord.
Not
Oh,
one
please,
year.
yes, less than,
Not 1 year, less than.
less than, my lord.
06 2014 to 37 2000.
10/3/2015, my lord.
So for 37 2000 47 2014
Yes,
till
yes,
22/1 2015 when you issued the memorandum. So it's
yes, yes,
less than 1 year.
yes, less than 1 year.
Yes, my lords.
Discipline force.
That's a issue, but my lords, they got me checked up in their own hospital. It's not, I'm not making any medical records. Their medical records reveal that I had suffered from Bell's palsy also. And this, my lord,
You suffered from everything. And you had a history of this. Article charge number 3.
Yes. Previously, my lord, for 40 days, my lord.
Oh, Mr.
Sorry.
is already in.
I'm sorry.
Why are you putting into more trouble?
my lord, see,
Tell me, give me one issue. One point, somewhere.
That is the point, my lord.
No,
They
that
get
is
me
not the
checked
point.
up.
You have not raised anything.
No, my lord,
You have admitted to the charges in the inquiry.
exactly that case, my lord, which lordship is holding now. No, in that also, therein also, my lord.
This is some civilian employee.
My lord, that's a different issue.
This is a
But, my
civilian
lord, in
employee.
that case
You are
also,
the
no, my lord.
discipline force.
Discipline force, my lord. What stopped me from discipline is that my issue, my medical issue.
Where is that? That you had that medical issue on that day.
My lord, they checked me on that
That
very day.
atrophy is normal.
They checked me on that very day when they caught.
If you check your brain cells and my brain cells, I guarantee that I will have somewhat less because of age. You're young. And if you have not wasted it in the manner not required.
It's a different that I refuse to answer. With due respect, my lord. But they get me when I was brought to the campus, my lords, they checked, but they conducted a medical test, my lords. That's all.
Yes, Mr. Odikari. He
Already.
came to the camp.
Yes,
Not
he was
denied.
brought. He was brought to the camp.
No,
Yes.
he came to the camp on the last date of his rejoining.
4/7/2014.
He came to the camp. You people spurned him away. He was your employee.
At 11 o'clock in the night.
Be that as it.
Yes.
He had come. Maybe he had some difficulty in coming.
yes.
He may have got stuck somewhere. You never made an inquiry with that.
Yes.
But in your affidavit, you accept that he had come. Right?
Yes. Yeah,
He was not an outsider. He was somebody who was there of the force itself, of that unit. It was his house. So you could not have spun him away.
Yes, my lord.
You should have allowed him to come in.
Yes,
One. Two, after he was arrested and brought,
yes.
what did you do? You sent him to the hospital. The hospital report. This is not a private hospital. The hospital
Yes.
report is with you
Yes,
because that hospital report will be given to you.
yes.
Now, as an authority, when you are considering his absence, was it not mandated on your part to also look into that document and then come to a conclusion?
Yes.
Saying that, okay, by perusing this document, we find that he is not suffering from that illness or that level of illness, which would have prevented him from coming. Fine. That would have been the end of the matter. Not done it.
My lord, what we did during the inquiry. my
When
lord,
did you die, Mr. Gogoi? The original petitioner died?
But he passed away
2019.
2019.
No, give me the date.
Second. Look at here, Nepali.
19/1/2019, I believe.
And otherwise, he would have retired when?
But he joined, when initially the
Yes.
matter was.
19/1,
just
this was 19 expired.
Initially, when it was filed, his age was 43.
43. So he would have retired sometime in. Oh, I'm bad in maths. Give me that.
15 plus 10, 40, 53, 53, 56, 56, somehow, 26, around 2030 minus
33.
30, yes, minus
32.
32 minus.
And he died on 19/1/19.
Right. Oh, yeah.
And the penalty is dated?
Penalty dated 1/9/2015.
We are interfering.
No, just one thing.
We are interfering with the penalty.
No, Lordship.
This period would be treated only for notional benefits till his death. Pension and pensionary benefits recalculated, normal basis. Whatever his family has drawn as family pension would be deducted and the balance be paid.
Lordship may do that, my lord. Lordship will hear me for one minute. But what happened, my lord, during the inquiry, my lord, the specific query was put to him.
Mr. Gogoi, you can take your seat.
Yes, specific query was put to him, my lord, whether, my lord, during this brief period, my lord, he had ever any treatment. And so, and whether he would like to place the documents on.
I'll take care of it.
Yes, my lord, my lord, he said, straightway he died, my lord. Yes.
With a loss of knowledge, with a lot of
Hey, my lord, for
knowledge.
this long period, my lord, he remained unauthorizedly absent. My lord, had he suffered from any disease, my lord, he would have visited some hospital, some doctors. He didn't do that. But he's a member of a discipline force, my lord. And my lord, this is not the first time.
Why did you not take your doctor's opinion into record? Your doctor
Yes.
had indicated
Yes.
something serious with him, which again fits with the plea he is taking. Why was that not taken into consideration by the inquiry of?
In the writ petition, Lordship will kindly see.
Where is that medical report, Mr. Gogoi?
In the writ petition, my lord, he has not pleaded. He has not said that he was under treatment.
14. Page 14.
Page 14.
He has not said that, my lord.
ADS, hypothyroidism, mild cerebral atrophy, brain. And the advice was also
Tape 3, temporary for 24 months, without firearm.
where do we
Advice on discharge.
discharge slip? Next
Yes.
page.
S3, madam, shape 3, bracket T24, temporary 2024.
He was an
without firearm.
alcoholic.
It
Yes.
seems so, my lord.
Previously also, my lord, for 40 days, he had remained unauthorized absent. Previously also, my lord, he was.
Gone. Why the family should suffer?
That is there, but Lordship will also look into it, because previously also.
I'm only on the facts and circumstances. I'm not laying down a law.
Yes.
Which is to be, it's only in the facts and circumstances of this case.
There, my Lordship will also kindly see, my lord. Previously also, my lord, 3 occasions, he remained unauthorizedly absent. My lord, he was given.
Oh, you regularize that? You regularize that 5 days, 3 days, 14 days, you
Yes,
regularize.
yes.
Now, if the charge number 1 and 2 I hold to be not proved or not established, charge number 3 by itself you cannot impose a penalty. It can only increase the quantum of the penalty with regard to 1 and 2. That's all.
Yes.
Nothing more, nothing less.
Previously also on a stoppage of annual increment for 3 years with cumulative effect, but he was a habitual absentee, and lordship's own judgments are there. Where lordship
I
has
made a
had,
mistake. Now I am rectifying.
yes, my lord, that division bench judgment is there, Kumar Kshetri's case, my lord. On the same line, I am having those judgments also.
Here only one document is troubling me, and that is the document of your own doctor.
That
You
is-
did not. You're nowhere. I saw it twice. Nowhere in the order I find a reference, even a reference to that. But you say he was sent to the hospital. Poor man. He's otherwise gone. Can't help it. Yes, Mr. Gogoi.
My lords, nothing more, my lords.
Pass the order.
All right.
Hut, Mr. D. Gogoi. Hey, you just see whether I lose out any facts.
My lords.
Learned counsel for the petitioner also heard Mr. So
Yep.
finally you are successful. How many days adjournment in this matter? 2, 3,
Too much head. 2, 3.
10, 2, 19, 1. After 8, 1, 1, 2, 3, 4, 5. Last date also you were indisposed.
Lord.
Now we'll keep a track on how many days you are indisposed this day.
My lords.
We'll keep a track. Lekha. But Mr. T. Gogoi, counsel for the that much banter I can have with him.
My lords.
Also heard Mr. M.R. Adhikari, learned CGC, appearing for the respondents. The petitioner in the present, full stop. At the outset, it is to be noted that the present writ petition was instituted by one Full Kumar Das, who is hereinafter referred to as the original petitioner. However, after institution of the present writ petition, the original petitioner passed on, Mr.
My lord.
What is the date? Yeah, I passed.
কি কৈছিলে আপুনি এইটো?
কি?
Regarding কোন তেতিয়া ঢুকাইছিলে? Right.
He expired on 19/1/2019.
Passed on 19/1/2019.
Wait. I saw.
এই কোন দিও? ইয়াত নাই আকৌ।
10/1/2019. So, accordingly, his wife, Srimati Ranu
Oh, yes, 10/1.
Das,
10/1.
approached this court by way of instituting an interlocutory application being I number 3379/2024, praying for permission to substitute herself in place of the original petitioner in the present writ petition. They said interlocutory application
Just 2 IAs were there. One was limitation. That was 3379 for limitation condonation.
and
And
the
3380
IA number
for substitution.
3380
for substitution.
was the Akil issue. Substituting herself petitioner in the present writ petition. Also, they said this court-wide order dated 21/5/2025, after considering the issues raised in the said proceedings, including the delay occasioning institution of the substitution application, proceeded to permit Full Ranu Das to substitute herself in place of the original petitioner in the present writ petition. Accordingly, also, the also, the original petitioner had instituted the present writ petition inter alia assailing an order dated 1/9/2015 issued by the
By my lords, the commandant, my lords, group center CRPF.
page.
Page 29, my lords, is English translated 34, it's
But
29
it's
is
the Deputy Inspector General by the Commandant, Group Center, CRPF, Gauhati, imposing the penalty of
compulsory retirement
with pension and gratuity upon the petitioner on conclusion of a departmental proceeding instituted against him. Also, as projected in the writ petition, from the materials brought on record in the writ petition, this court finds that the petitioner had proceeded on earn leave for 30 days with effect from 4/6/2014 to 3/7/2014. The petitioner was to report back for his duties on 3/7/2014 by the time of the evening roll call. However, the petitioner remained absent and however, it is found that the petitioner did not resume his duties. Also, it is projected in the writ petition that petitioner had reported for duties on the next day, that is 4/7/2014 at late night hours. However, the security at the gate to the unit of the petitioner did not permit the petitioner to enter into the premises of the unit, and he was required to leave the place. Inasmuch as the superior officers had verbally directed the security personnel not to permit entry into the premises after evening hours. Also, it is further projected that, left with no other alternative, the petitioner proceeded back to his native place with the intention of coming back, with the intention of reporting back the next day. It is projected that the petitioner from the next day developed serious headache and had a loss of memory, which is projected to have continued from 4/7/2014 to April 2015. Also, in the meanwhile, the petitioner not being found to have reported for his duties, the respondent authorities had declared the petitioner to be a deserter with effect from 4/7/2014. Govinda, second of what I would. 4/7/2014. Also, thereafter, a warrant of arrest was issued, which was executed on 10/3/2015 by the civil police, and the petitioner was produced before the group center CRPF at Gauhati on 10/3/2015. It is further projected that on such production of the petitioner, the petitioner was forwarded to the composite hospital CRPF at Gauhati for his medical examination. The petitioner thereafter continued to receive treatment in the medical hospital with effect from 10/3/2015 to 10/4/2015. It is projected that in the discharge slip, it was highlighted that the petitioner was suffering from apostrophe, ADS with hypothyroidism, page 15 of the week, and page 15, mild cerebral atrophy, ATROPHY, bracketed brain. So after the the petitioner's discharge slip further mandated that he be, where do you get that he be given light work?
There's a column, my lord, advice on discharge on the bottom part, advice on discharge. As
Was advised duties without use of firearm. So after the discharge of the petitioner, his disciplinary authority proceeded to institute a disciplinary proceeding against the petitioner while issuance of a memorandum of charge dated 22/1/2015. 3 articles of charge were framed against the petitioner. The first 2 articles of charge, the petitioner participated in the inquiry that followed the issuance of the said memorandum of charge, and on conclusion of the conclusion of the inquiry officer submitted his report wherein the charges leveled against the petitioner was found to have been established. So accordingly, the disciplinary authority of the petitioner, by order dated 1/9/2015, considering the materials coming on record, by concurring with the findings recorded by the disciplinary authority, by the inquiry officer, proceeded to impose upon the petitioner the penalty of compulsory retirement from service, with pension and gratuity. Also, no appeal and all were filed.
No.
Being aggrieved, the petitioner has instituted the present writ petition. Mr. D. Gogoi, learned counsel for the petition, after reiterating the facts noticed herein above, has submitted that the petitioner, on being produced before the respondent authorities upon his arrest on 10/3, after his arrest on 10/3/2015, was sent by the respondent authorities to the Composite Hospital Group Center, CRPF Gauhati on 10/4/2000, was sent for medical examination. He submits that the report submitted by the officer, by the said hospital, would reveal that the petitioner was suffering from mild cerebral atrophy, bracketed brain, which he contends to be a disease which has the effect of the brain cells being damaged. Mr. Gogoi further submits that the respondent the said report, medical report, being of the hospital of the respondents, the same was available with the respondent authorities. However, during the inquiry officer nor any other witness deposing in the inquiry had referred to the said report. Mr. Gogoi, by taking this court through the order dated 1/9/2015, passed by the disciplinary authority, contends that the opinion rendered with regard to the health condition of the petitioner by the doctors of the Composite Hospital was not even referred to in the said order. Mr. Gogoi further submits that the absence of the petitioner was on account of the memory loss caused to him on was on account of the memory loss occasioning because of the ailment suffered by him. He submits that the said reason assigned by the petitioner is found to be established from the medical report submitted in the matter by the doctors of the composite hospital of the respondents herein. Accordingly, he submits that the absence of the petitioner being justified, the said period cannot be held to be unauthorized absence, and the petitioner's justification was mandated to be considered by the respondent authorities. Accordingly, he submits that no misconduct can be said to have been committed by the petitioner in the matter, inasmuch as he had to remain absent on account of reasons beyond his control. Anything more?
No, Manoj, that'll suffice.
Accordingly, Mr. Gogoi submits that the impugned order dated so and so would mandate an interference with this by this court. Per contra, Mr. Gogoi has submitted that the fact that the petitioner had come to his unit for rejoining after availing leave, on 4/7/2014, albeit at night hours, is not denied by the respondents in the affidavit.
Right.
Per contra, Mr. M.R. Adhikari, learned CGC, submits that the petitioner had remained unauthorizedly absent after 3/4/2017, inasmuch as no intimation with regard to his such absence was given to the authorities of the unit at any point of time. He submits that in the event the petitioner was in such a position that he is not in a position, he was in such a position of being not able to communicate with his unit, his family members, who is projected to have also accompanied him on 4/7/2014 at late night hours, ought to have communicated the condition of the petitioner to the unit officials. He finds that there is no material brought on record by the petitioner to demonstrate any such communication being made. Accordingly, he submits that in absence of any intimation with regard to the reason for the absence of the petitioner, the set period of absence of the petitioner must be held to be unauthorized. Mr. Adhikari, by referring to the contentions raised by the petitioner in the present writ petition, has submitted that there is not even a indication made even in the present writ petition, at least in the present writ petition, of the nature of treatment received by the petitioner for the ailment suffered by him after 3/7/2014 till 10/3/2015, when the petitioner was forwarded to the composite hospital of the respondents for treatment.
From the previously also, my lord? So he was a heavy, he's in heavy.
Accordingly, Mr. Adhikari has further submitted that during the inquiry, the petitioner had not brought on record any material any material and or contention to justify his absence. Accordingly, the inquiry officer, basing on the materials coming on record in the inquiry, proceeded to conclude that the articles of charge number 1 and 2 stood established against the petitioner. Mr. Adhikari submits that the article of charge number 1 and 2 having been established, the disciplinary authority, for the purpose of determining the quantum of punishment to be required to be imposed upon the petitioner had taken note of the article of charge number 3, which again relates to similar misconduct committed by the petitioner in the past, for which he was punished. Accordingly, Mr. Adhikari submits that considering the present misconduct which formed the basis of article charge number 1 and 2 of the memorandum of charge dated 1/9/2015, the disciplinary authority proceeded to take a lenient view in the matter and impose the penalty of compulsory retirement from service with pension and gratuity. Accordingly, Mr. Adhikari submits that submits that the penalty as imposed upon the petitioner by the order dated 1/9/2015 would not mandate any interference. Yes, Mr. Gogoi, anything more?
Nothing, man. So my absence was not willful, and then everything was on their report.
Willful?
No, not willful, man.
It's not it is justified. Which paragraph of this judgment you want to rely? This is with regard to proportionality.
This is not helping me, man. I'll fall back to that Parmar.
This is not helping. That's why I said.
Parmar case is not provided.
Parmar
to
also
him.
we are not.
No.
We are not even.
Even Dhariwal, Parmar.
Oh, I will give my own reason.
Well,
Oh, Mr. Gogoi. I think I have troubled him much in this case.
No, there was another approach.
That was only with
Otherwise-
I wanted something out and I got it today. So, okay, fine.
Lordship's judgment in Dilip Gogoi's case, that police constable case, habitual absenteeism, I had the copy. Then again in Kumar Chetri's case, authored by your Lordships in division management, even I am relying on those judgments also. May I please?
All those are in the fact situation of those matters.
But fact remains that Kumar Chetri's case is squarely covered. Because here he has taken a plea of mental illness, but he could not produce any documents.
No.
Yes.
In Kumar Chetri, and here the distinguishing factor would be, if you want me to trouble me to that extent,
My lord.
I take that trouble and I'll write it down. Was that Kumar Chetri remained with the plea that he was suffering. There was no corresponding medical document. Here, there is one medical document of your own.
That is, after he was
Be that
arrested.
as it may, brain atrophy does not occasion immediately.
But he
It takes time.
Yes.
It takes time.
But the fact remains that from
See, Mr. Adhikari, if you had considered that document and said this is only a reasoned origin, I would have dismissed his case. That's the only thing which is. Yeah, 226 code
now since
cannot go into.
yes,
should not
but
be that
fact remains.
oblivious of a condition of a man.
Discipline force.
The facts, of course, heard the learned counsel for the parties also peruse the materials brought on record. So, the facts noticed herein above are not in dispute. Accordingly, the same is not reiterated. So, next, the petitioner was while memorandum of charge dated, a departmental proceeding came to be instituted against the petitioner while issuance of a memorandum of charge dated 22/1/2015. 3 articles of charge came to be framed against the petitioner therein. The articles of charge as framed against the petitioner being relevant, the same is extracted here in below. Page 17, A to A. I do come back to Siluni. A perusal of article of charge number 1 would reveal that the petitioner, who was serving as a constable general duty in the headquarter company of the group center, Central Reserve Police Force, had committed a misconduct inasmuch as after availing only for 30 days from 4/6/2014 to 3/7/2014, he was required to report back in the evening of 3/7/2014, but the employee remained absent from 4/7/2014 without permission or leave from the competent authority. Also, the materials brought on record would go to reveal that admittedly the petitioner had not reported back for his duties on 3/7/2014 before the evening roll call. However, the petitioner's projection that he along with his family members had come to the unit on 4/7/2014, however, at late night hours with the object of rejoining his services, but was prevented from entering the premises of the unit by the security personnel is not disputed by the respondents. The respondents in the affidavit have also admitted to the position that the petitioner had come to the gates of the unit on 4/7/2014 for resumption of his duties, but he was not permitted to enter the premises inasmuch as there was a standing instruction not to permit any person, including personnel of the force, to enter the unit premises after evening hours. Accordingly, the fact that the petitioner had attempted to resume his services is not disputed. Also, the petitioner thereafter has projected that he had suffered a severe headache and had a corresponding memory loss, for the reason of which he was not in a position to understand as to what was happening till around April 2015. The petitioner is found to have been declared a deserter on 4/7/2014, along with the issuance of a warrant requiring his arrest. The warrant of arrest was executed by the jurisdictional police station on 10/3/2015. Also, on his such arrest, the petitioner was produced before the Chief Judicial Magistrate cum Commandant CRPF, and he was kept in judicial custody. The petitioner was thereafter released from judicial custody and sent to the Composite Hospital, CRPF, Gauhati, for medical checkup. Also, the petitioner continued in the Composite Hospital under treatment from
10/3/2015 to 10/10/4/2015. Also, you'll find a discharge slip, date of admission and date of discharge.
from 10/3/2015 to 10/4/2015. Also, in the discharge slip issued to the petitioner, it was recorded as follows. Page 15, A2, A apostrophe B dot. Also, further, the petitioner was directed to be deployed for duty without firearms. Also, the petitioner was the doctors examining the petitioner in the Composite Hospital had held the petitioner to be suffering from mild cerebral atrophy. Also, be that as it may, it is thereafter that the memorandum of charge dated so and so with the article of charge number 1 was issued to the petitioner. The materials examined by the, from the order dated 1/9/2015, wherein there is a detailed examination of the inquiry proceedings as well as the report of the inquiry officer, this court does not find any reference being made to the said opinion of the doctors of the respondents, doctors of Composite Hospital, which is a hospital of the respondents. Also, the said opinion of the doctors would go to reveal that there was that the absence of the petitioner from his services with effect from 4/7/2014 was on account of a situation he found himself in, which was beyond his control. Accordingly, they said diagnosis, said opinion of the medical doctors of the Composite Hospital justifies the absence of the petitioner. Also, the respondent authorities had the said opinion with them when the departmental proceeding against the petitioner was being conducted. However, it is found that the said opinion was not factored in by the inquiry officer before submitting his opinion in the matter. The said opinion was also not factored in by the disciplinary authority before passing the impugned order dated 1/9/2015. Accordingly, this court is of the considered view that from the materials brought on record, it cannot be held that the absence of the petitioner was unauthorized. That is to mean that it was without a justified cause. There being a justified cause coming on record with justifying the absence of the petitioner, this court is of in the facts and circumstances arising in the present writ petition holds that the period of absence of the petitioner cannot be held to be unauthorized in any manner. Accordingly, no misconduct is found to have been committed by the petitioner within the meaning of section 11 bracketed 1 of the Central Police Force Act 1949. So, in view of the above conclusions, this court holds that the article of charge number 1 to have not been established against the petitioner. Also, with regard to article of charge number 2, the same is found to have followed from the article of charge number 2, and the same alleges that the petitioner, although was issued with communications to report back for duty, he had not reported back nor prayed for extension of leave. From the order dated 1/9/2015, this court finds that the inquiry officer, you have the statements with you?
Yes.
See the statement of 1, 2, and 5. Basing on the statements of the witnesses number 1, 2, and 5 in the inquiry, had proceeded to hold the had proceeded to hold the article of charge number 2 to have been established.
I have the translated copies. And I have the statement of the petitioner also, my lord.
Forget the statement of the petition, the inquiry report.
Because a specific query was put to him there, my lord, regarding his treatment. During the
I've recorded that. The inquiry report is here somewhere.
My lord, I have. Uncle, hey.
Like,
Yes, I got that. I have with me, my lord.
One, two, and five.
I did.
Was held to be established by the statements of the witnesses number 1, 2, and 5. This court, Mr. Amir Adhikari has furnished the inquiry report as well as the statements of the witnesses. This court, on perusal of the statements, is find that only a statement was made to the effect that notices were issued to the petitioners at his residence, a residential address requiring him to resume his services. However, nothing was brought on record to demonstrate that the said notices were in fact served upon the petitioner and or his family members. So accordingly, this court, in view of the materials coming on record, holds that the second article of charge number 2 also cannot be held to have been established. So, article of charge number 3 only pertains to the past misconduct of the petitioner. The same would be relevant only in the event the article would be relevant for the purpose of the determination by the disciplinary authority of the quantum of penalty to be imposed upon the petitioner if the articles of charge number 1 and 2 are held to have been established. This court, having held the articles of charge number 1 and 2 to have not been established, the article of charge number 3 by itself cannot be the reason for imposition of any penalty upon the petitioner. Accordingly, a further discussion on the article of charge number 3 would not be mandated. So, for the reasons as assigned herein above, this court finds that the penalty that the articles of charge number 1 and 2 having not been established, no penalty was mandated to be on the absence of the petitioner in the considered view of this court, in the attending facts and circumstances involved in the matter, cannot be held to be unauthorized, accordingly, the petitioner is held to have been accordingly, the impugned order dated 1/9/2015 stands set aside. The petitioner is held to have continued in his services with effect from 1/9/2015. So, as projected herein above, has noticed herein above, the petitioner herein, the original petitioner herein had passed on 19/1/2019. So accordingly, the respondents would now full stop. However, considering the fact that the petitioner had not rendered any service, original petitioner had not rendered any service with effect from 1/9/2015 to 19/1/2019, this court is of the considered view that the petitioner would not be, original petitioner would not be entitled to be granted any back wages. However, the period with effect from 1/9/2015 till 19/1/2019 shall be regularized and the salary of the petitioner be notionally calculated and fixed as on 19/1/2019 for the purpose of fixation of his pension and pensionary benefits. Also, the pension and pensionary benefits now becoming due in the matter, along with the pension and family pension and other pensionary benefits becoming due in the matter in respect of the services rendered by the petitioner, which is now to be deemed to have been so rendered till 19/1/2019, be processed, and on such processing be made, the same be released to the present petitioner, Runu Das, within a period of 3 months.
3 months.
3 months from the date of receipt of a certified copy of this order. Full stop. With the above observation and direction, the present petition stands allowed.
Always managed. And the date of that is 10/1/2019. And the name is Ranu.
Ranu Das. That she will not forget. Her name is also Ranu. So that will be correct. So you have succeeded in misrepresenting and taking an order.
No, Alice is totally different approach. I'm learning, so that's having some issues.
You are now a teacher.
My lords.
Oh, Mr.
Yes, sir.
It would be better. You can use it somewhere else.
Yes.
Yes, Mr. Das. Mr. Doctor, what are you waiting for?
There is one item number 8, which is Lordship.
Will take some time because I have to dispose of some more matters. I've just completed 1, 2. So now item number 2 is there, 4 is there, then 7, and then 8.
Some other day.
One thing, Mr. Doctor.
The
Postal employee.
notification.
Give me again, just a query. Postal employee. Departmental proceedings. Proceedings instituted before this court.
Proceedings.
Instituted before this court. 2016. Pending. Admittedly, the jurisdiction is with the central administrator.
Yes.
Now, what should this court do in such circumstances?
Lordship can relegate the matter to the tribunal.
After 10 years, pending here for last 10 years, this issue was not highlighted.
Otherwise also.
I don't have jurisdiction.
Yes.
And I don't have jurisdiction.
There are decisions. In fact, in one of the cases, I had done it long time back. Jurisdiction cannot be conferred either by conscience, consent, or
Even
by.
the court cannot confer. No power. Okay, I'll hear. Yes, Mr. Bhatt. Where is Mr. Nair? Oh, Nair is not here.
He's not.
So his condition.
I think, my lord, we should not. His condition.
On the prayer of the learned, to me, election petition. On the prayer of the learned counsel for the parties. When? This time, I think we will finish it off.
Yes, maybe in the month of July, no? After 27, after. By that time, it's Parso also.
As agreed to by the learned counsel for the parties. So what naam likhe lo, buddy?
27?
Registry to list this matter again on 27/7/2026. Also, matter stands adjourned today. Full stop. as agreed to by the learned counsel for the parties, registry to list this matter again on 27/7/2026 along with the pending interlocutory application.
I am deeply aware.
Tutate eke order.
Yes, deeply aware.
So, hope everything is fine.
This now is under,
Huh?
this now is under control, but is some infected sometime.
Infection now.
That's the only, I remain in contact with him.
No, I've not talked to him for a long time. I'll have to.
Yes, sir, that's.
Sir, item number 8 is also your
Ah,
lordship.
we'll do it. If time permits, I'll dismiss that matter today. Don't.
Now, another thing I just wanted to say, in case your lordship relegates the postal matter, then perhaps the question of delay will come.
We will say, request the tribunal to
Yes.
keep that thing, this pendency of the proceeding here in mind when they consider that application. Thank you. Don't worry, it's only a matter of time now.
I have found out something.
No, you found out, will not permit you.
Yes, fellas.
I've permitted you one. That is enough for the day. I have to. Heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. B. Kaushik, learned standing counsel, Department of School Education. The petitioner in the present proceedings has questioned the appointment of the private respondent number 8 as the principal of
Bagimbor Nilamani Fukan Higher Secondary School.
Bagimbor Linomoni Fukan Higher Secondary School, Dibrugarh. Also, as next, Sarah, as projected in the writ petition, Mr. Sharma, please have a seat. As projected in the writ petition, the petitioner hearing was included as a member of the School Management and Development Committee of Bagimbor Ilomoni Fukan Higher Secondary School. Also, the post of principal of the college being vacant, in pursuance to the guidelines issued by the Government of Assam in the Secondary Education Department, wide office memorandum dated 6/6/2014, laying down the procedure to be followed for selection or against the post of principal in a provincialized higher secondary school, an advertisement dated 1/9/2017 came to be issued by the chairman of the school management and development committee of the school in question. Also, for the purpose of conducting the selection in question, a selection committee was constituted with the president of the SMDC as its chairman, along with 2 subject teachers of the school as members. One Horabala Deka was also incorporated in the selection committee as a parent member. Also, the petitioner projects that while the school selection committee was so constituted in the meeting of the school SMDC, therein the name of the parent member was not incorporated, which was subsequently so incorporated. Also, the interview for the selection was held on 9/9/2017, and the statement of marks was forwarded to the inspector of schools by the selection, by the secretary, by the selection committee in respect of 3 persons who had participated in the selection process, including the respondent number 8 hearing. It is projected by the petition that there were in fact 7 candidates who had participated in the selection process. However, only the names of 3 came to be so forwarded. Also, The petition alleging that the selection committee not being the petitioner has further alleged that the parent member had not participated in the selection process in as much as his signatures is not found to have, he is not found to have appended his signatures in the selection committee minutes. However, in the forwarding of the marks of 3 candidates, the signature of the parent member is found. So, basing on the said premises, the petitioner had approached the respondent authorities with a prayer for annulling the selection process undertaken by the respondent authorities. Also, the representation submitted by the petitioner not being considered by the respondent authorities, the petitioner had approached this court by way of instituting a writ petition, being WPC number 1054/2018. So, the said writ petition was disposed of by a coordinate bench of this court with a direction to the respondent authorities to consider the contentions raised by the petitioner in his representation after giving him a due opportunity. After giving to the petitioner and others involved, including the respondent number 8 herein, a due opportunity of hearing. Also, the Commissioner and Secretary, Government of Assam, Elementary Education, basing on the representation of the petitioner and the materials coming down during the hearing held, proceeded by order dated 21/7/2018 to dispose of the representation submitted by the petitioner by rejecting his claim with regard to the challenge presented to the appointment of the respondent number 8 as the principal of the school. Also, subpara. Being aggrieved, the petitioner has instituted the present writ petition. Mr. R. Sharma, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the selection committee in question not being constituted in the manner as mandated, the selection stood vitiated, and accordingly, the petition respondent number 8 having been selected in pursuance to a vitiated selection process, her such selection would mandate an interference. Consequently, he submits that the appointment order of the petitioner would also mandate an interference. Also, the learned counsel for the petitioner, by referring to the additional affidavit filed by the petitioner in the matter, has projected that the minimum qualification required for appointment against the post of principal in a college is that the candidate must possess a master's degree along with a B.Ed degree. It is projected that the petitioner who had joined her services in 1999 as a subject teacher. As a subject,
Yes.
huh?
As a subject teacher.
As a subject teacher, had a graduate teacher, as a graduate teacher, sorry, it's 17 years, it will be graduate teacher, had pursued her master's degree only in the year 2014, without, however, taking requisite permissions from the departmental authorities. He submits that the said degree as procured, as acquired by the petitioner, would be of no consequence, and the same cannot be held to have made, and the same cannot be projected by the respondent number 8 with regard to, but cannot be relied by the petitioner for demonstrating that she fulfilled the requisite eligibility criteria for participating in the process of selection for the post of principal of a provincialized school in the state. Also,
One more
The advertisement first published in the year 2016 was not taken affected. Then re-advertisement was done.
Every advertisement, the cutoff date is 1/1/2016.
Yes, and if
So
it
she
is
does
so-
not have 40.
If that is what one thing, and the second thing is that the 15 years of experience that shall not be completed if it is 19.
We'll see. We'll see that. Also, he has further, Mr. Next, Mr. 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 Sharma further submits that the advertisements issued, the final advertisement issued in the matter on, when was the last advertisement issued?
1917.
On 1/9/17 had mandated that the candidate must not be less than 40 years of age as on 1/1/16. It is submitted that from the marks, from the select list as prepared in the matter, from the comparative statement of the candidates prepared by the selection committee, it is seen that the date of birth of the petitioner is recorded therein as 1779, and accordingly it is to be held that as on 1/1/2016, the petitioner had not completed 40 years of age by reckoning a date of birth to be 1/7/1979. Accordingly, he submits that on the set count also, the petitioner is to be, respond number 8 is to be held. Respond number 8 is to be held to be ineligible for being considered for the post of principal, and the consequential appointment effected in respect of the respond number 8 would mandate an interference from this court. Mr. Sharma, by referring to the advertisement dated 1/9/2017, submits that the cutoff date therein being prescribed as 1/1/2016, the 17 years of experience mandated as a graduate teacher in a higher secondary school in respect of the petitioner being reckonable only with effect from, what was that date? There is a joining report somewhere. With effect from 29/11/1999, comma, the petition, respond number 8 is found to have also not acquired the requisite teaching experience for being considered for appointment as a principal in a provincialized higher secondary school.
Also, it is a continuation of earlier advertisements. Earlier was not given.
1/1/2016.
Yes, also.
Also. Mr. Sharma, in the above premises, submits that the petitioner not being eligible to have been for participating in the selection process, comma, the respondent authorities committed an illegality in allowing the petitioner to respond number 8 to participate in the selection process, and accordingly such selection along with the consequential appointment effected in her case as the principal of so-and-so school would mandate an interference from it. Per contra, Mr. B. Kaushik, Learned Counsel for the petition, has submitted that the claims made by the contentions raised by the petitioner in his representation, comma, dated 14/1/2018, in pursuance to the directions passed by this court wide the order dated 23/2/18 in WPC number 1054/2018, were duly considered by the Commissioner and Secretary, Government of Assam, Elementary and Secondary Education Department, and on a due consideration of the same, conclusions were drawn, and the wide order dated 21/7/2018, due conclusions were drawn with regard to each of such points contentions raised by the petitioner in his written in his representation. Accordingly, it is submitted that the conclusions reached by the in the speaking order dated 21/7/2018 would not mandate an interference from the court. Mr. Kaushik has further submitted that the issues raised by the petitioner by way of filing additional affidavits were not projected before the Commissioner and Secretary, Government of Assam, Elementary and Secondary Education Department during the hearing of the matter, which on conclusion of which the order dated 21/7/2018. He submits that the said issues raised in the additional affidavit would not mandate a consideration by this court. Also, in the above premises, Mr. Kaushik submits that the impugned order dated 21/7/2018, along with the appointment of the petitioner as principal of the school in question, would also not mandate an interference by this court. I've heard the learned counsel for the parties and peruse the materials available on record. So, the facts noticed herein above are not in dispute. Accordingly, the same is not reiterated herein. The petitioner had submitted a petitioner. At the outset, it is to be noted that the petitioner is not a candidate for the post of principal of the college in question. However, being a member of the selection committee of the school management and of the SMDC of the school, he has instituted the present writ petition assailing the selection and appointment of the respondent number 8 by praying for issuance of a writ of quo warranto. Also, a writ of quo warranto having been prayed for in the present writ petition, the petitioner would have to be held to have locus to institute the present proceedings. Accordingly, the present proceedings would mandate a consideration on merits. Also, the facts noticed here, facts noticed herein above are not in dispute and accordingly are not reiterated. The petitioner being aggrieved by the appointment of the respondent number 8 had approached the respondent authorities by way of submission of representations. Also, the representations so submitted were submitted by the petitioner through his counsel. Also, the said representations not being in the said representations, the petitioner had essayed the selection of the respondent number 8 solely on the ground that the selection committee constituted in the matter was not so constituted in terms of the procedure laid down for the same. The petitioner had further in the said representation highlighted that the parent member of the school not being having not participated in the selection process, the said selection cannot be deemed to be a selection carried out by a duly constituted selection committee. Also, the representations of the petitioner not being considered by the respondent authorities, as noticed herein above, he had approached this court by way of instituting a writ petition being WPC number 1054/2018. The said writ petition was given a final consideration by this court, wide order dated 23/2/2018. Also, this court directed the commissioner and secretary, or the departmental commissioner and secretary, to consider the representation submitted by the petitioner after giving him a due opportunity of hearing, along with the other affected persons, including the respondent number 8 hearing, and thereafter to pass a reasoned order on the grievance of the petitioner. Also, the said representation was disposed of by the Departmental Commissioner and Secretary by way of issuance of an order dated 21/7/2018. A perusal of the said order dated 21/8/2018 reveals that for the purpose of disposal of the representation submitted by the petitioner, a hearing was held in the matter, and therein the petitioner as well as other affected persons, including the respondent number 8 hearing, were given an opportunity of hearing. So, in the said order with regard to the grievance raised by the petitioner that the selection committee was not so constituted as per the guidelines laid down in this connection, why the office memorandum dated 6/6/2024, the departmental commissioner and secretary had submitted, had concluded, basing on the materials coming before, on record before him, that a senior-most teacher of the school had acted as the member secretary of the school selection committee, as the principal in charge of the school, Lakshmi Prasad Saikia, was a candidate for this post. Further, notice that one Rupa Datta, subject teacher, was made a member along with one Haravala Deka, who was incorporated in the selection committee as a guardian member. The departmental commissioner and secretary also noticed that the records revealed that one Jayanto Kumar Sharma, who was the president of the school SMDC, had acted as the chairman of the selection, had chaired a meeting on 6/9/2017 of the SMDC, wherein discussion on the selection of principal, wherein the issue of selection of principal was one of the agenda items. Also, it was further noticed that the minutes of the said meeting revealed that one Harabala Deka was elected as the guardian member for the school selection committee formed by the SMDC for selection of the principal. Also, accordingly, the departmental commissioner and secretary further noticed that the panel list prepared by the selection committee were signed only by the selected members. The guardian member, signature of the guardian member was not found. However, the guardian member during the hearing had acknowledged his presence on the date of interview and that there was no note of dissent found to have been appended to the said panel list. Also, accordingly, it was concluded that there was no material to demonstrate that there was any deviation made by the selection committee in the selection process. Also, it was further noticed that the minutes of the decision of the selection committee were again considered by the state selection committee, and the state selection committee had also, on consideration of the matter, recommended the name of the respondent number 8 for appointment as the principal of the college. With regard to a further issue raised by the petitioner before him, the departmental commissioner and secretary had noticed that the appointment letter in respect of the respondent number 8, although issued earlier, had reached the office of the jurisdictional inspector of schools only on 5/1/2018. It was found that immediately thereafter, that is on 6/1/2018, the respondent number 8 had joined her services. Accordingly, it was held that there was no delay on the part of the respondent number 8 in joining her services as a principal of the school in question after she was served with a copy of the appointment order. So, for the above reasons, the departmental commissioner and secretary proceeded to reject the claim made by the petitioner in his representation. This court, on a perusal of the conclusions reached by the departmental commissioner and secretary with regard to the issue of constitution of the selection committee as well as the delay occasioning in the petitioner joining her services, finds that the said reasons assigned are germane to the issue, are reasons born out of the records, born out of materials coming on record during the inquiry held, during the hearing held in the matter before him. Accordingly, a contrary position not having been demonstrated by the petitioner in the present proceedings, the said conclusions would not warrant an interference by this court. Having drawn the set conclusion, wait, there is more. Having drawn the set conclusion, this court would now consider the further issues.
Point only, Lordship. The person horrible of data, he gave a statement. It is annexed in the petition.
But here, the hearing, he gave a different statement.
But he given.
That is a statement given in extrajudicial conference.
No, it is addressed to the Ayukta Hosip Madhyamik Shiksha.
He gave, that is a different thing here. And in the forwarding, his name is there. He signed there. Might not have signed. The further issue, having drawn this set conclusion, this court would now consider the further issues raised by the petitioner in the present proceeding. The petitioner had raised an issue with regard to the validity of the master's degree in ASMIS as acquired by the petitioner in the year 2014 from Dibrugarh University. It is submitted by the petitioner that the said degree is invalid in as much as the same was so pursued. The course involved was so pursued by the respondent number 8 without obtaining prior permission for pursuing the said course from the departmental authorities. The said issue did not detain this court any further, in as much as the same is no longer res integra and has been settled by the decision of this court in the case of Tonkeshwar Nath versus State of Assam. WPC number ekini paribane ase second no moi didi me. Also, accordingly, the contentions raised by the petitioner with regard to the petitioner pursuing her MA Master of Arts course in ASMIS without prior permission stands rejected. The petitioner has further raised an issue that on the date when the petitioner had submitted her application in pursuance to the advertisement dated 1/9/2017, she had not acquired the age of 40 years and accordingly was not eligible for being considered for the post of a principal of the school in question. Also, the advertisement dated 1/9/2017 stipulated that the intending candidate for the post of principal as advertised must be not less than 40 years of age as on 1/1/2016. The petitioner projects that from the materials, from the comparative statements prepared by the selection committee, it is seen that the petitioner's date of birth was recorded therein as 1779. Accordingly, she would not have acquired the age of 40 years as on 1/1/2016. This court has examined the materials available on record in this connection and finds that from the statement of marks prepared by the selection committee, 2 dates of birth of the petition of the respondent number 8 is borne out. One being 1779 and the other being 1974. The petitioner has not brought on record any material to demonstrate as to amongst the set 2 dates, which of the date is the actual date of birth of the respondent number 8. Also, in absence of any material being brought on record, which would conclusively establish that the date of birth of the petitioner is 17/1979, this court is not in a position to further adjudicate the said issue and would proceed to consider that the date would proceed to hold that the date of the birth of the petitioner is to be deemed to be 1/7/1974, and the respondent authorities having found the petitioner to be eligible for being appointed for participation in the selection process, the petitioner is found to have completed the age of 40 years as of 1/1/2016. Accordingly, the said contention raised by the petitioner stands rejected. The above discussion would now bring the court to the further issue raised by the petitioner in the present proceedings in the additional affidavit. The petitioner, basing on a RTI reply received, has contended that the Dibrugarh University authorities in the said RTI reply had projected that there was no candidate by the name Meenakshi Fukan who had appeared in the Master of Arts final examination in education from Dibrugarh University in the year 1999. So, amongst the documents received by the petitioner under RTI from the competent authorities also includes document pertaining to the master's degree in education pursued by the petitioner, but also includes the mark sheet issued to the petitioner with regard to the final examination of the Master of Arts in Education examination, a course undergone by her from Dibrugarh University, wherein the roll number of the petitioner is also borne out. The petitioner is not found to have projected the RTI question by also disclosing the roll number of the petitioner herein. Accordingly, the reply as submitted by the Dibrugarh University authorities, that university as noticed herein above, would not be conclusive proof of the fact that the person who had pursued the who had pursued the Master of Arts in Education course in the year and appeared in the final examinations held in the month of August 1999 with the roll number 4 was not the petitioner, was not the respondent number 8 herein. Further, it is found that the petitioner had already had acquired her master in Masters in Arts examination in SMS under distance education mode from the Dibrugarh University in the year 2014. there is no material brought on record to question the validity of the said degree, master's degree acquired by the respondent number 8 herein. So accordingly, this court, basing on the materials brought on record, finds that the respondent number 8 had the requisite educational qualifications as well as the professional qualification in terms of the provisions of the 2003 rules of the Assam Secondary Education bracketed provincialized bracket over Service Rule 2003 as amended for being recruited to the post of principal of the school in question. Accordingly, in view of the above discussion, none of the contentions raised by the petitioner in the present proceedings would mandate an acceptance from this court. Accordingly, the present petition is held to be devoid of any merit and the said stands dismissed. However, there would be no order as to cost.
Only that 17 years experience.
17 years, okay, that I missed out, no? So the further issue raised by the petitioner is that she had not acquired 17 years of teaching experience inasmuch as she had joined her services as a graduate teacher only on 29/11/1990. The said contention of the petitioner is so based on the presumption that the said teaching experience is mandated by the candidate to be so acquired with effect from acquired as on 1/1/2016. So, this court has perused the advertisement dated, has again perused the advertisement dated 1/9/2017 and finds that therein, where is that advertisement?
Page 25 and earlier advertisement at page 57 and 58.
50? No. The subsequent advertisement. The last
Page
one
25.
does not find that the said experience was so teaching experience was so mandated to be acquired as on 1/1/2016. The stipulation with regard cutoff date as of 1/1/2016 was prescribed in the advertisement only with regard to the age qualification and not for any other purpose. Also, a perusal of the office guy of the rules of rule Rule 12 of the rules of 2003 would also reveal that there is no prescription of any cutoff date with regard to the acquisition of the teaching experience set out therein. Also, it is only with regard to the age qualification that a specification was made that the same was to be so acquired with regard as on the first day of the year of recruitment. Also, the petitioner is found to have completed 17 years of teaching experience with regard to the last date of submission of applications in the matter, which was so fixed on 4/9/2017. Accordingly, the said contention raised by the petitioner would also not mandate any interference from this, would not mandate any acceptance from this court. Baki, last thought, is it but yeah, लिखी थी पांडव. Yeah. Anything further?
My lord, it's only those things which I spoke last time.
All disputed, we can't go into it. Your identity is not reflected.
The only thing is, my lord, when we filed a case, I mean the first writ petition, when we filed, which is also pending, when we filed that for arrear and current salary, after 2 years, they took the plea that, I mean, this order was passed, the suspension order was passed.
No, but there is something before that also, that inquiry, whether you were there, that DC's letters, the director's letters, the finding that you are not there, those are there.
That lordship, we can only know from this, we have come to know from this 2017 order, which was passed. There it was mentioned. There in the first line itself, this thing was mentioned.
When did you file the first case? 15.
First case was 15 years. So anyway, lordship, the thing is that.
But that came to their notice only then.
This is also disputed, Lordship. We have filed our affidavit.
No, we have seen. Delivery of order, no. But the learned counsel for the parties at length, hearing concluded, Namgita Liluba. Registry to list the matter on data dia. 16.6 for delivery of orders. But I will dismiss the repetitions, but give you liberty to approach the competent forum, court of civil jurisdiction, to establish that you are Sujaira Bin. With this material, disputed question, this court cannot.
So that's why, lordship, I'm also not saying much, as the registry has conducted in this thing inquiry, police has conducted. Thereafter, I'm no one to say something more. I mean, whatever is there, it's on record only.
If you want that liberty without me coming in, if you want it, we can give you that liberty to approach the civil court. Because if I do it, I'll have to go hold that you are not entitled. That will sway the mind of the, even if I write,
Yes,
it will sway. So if you want that, you withdraw it, you go. I'm giving you, because there is no point in continuing with this.
Yes. But so far as withdrawal is concerned, then of course I can.
Okay, fine, forget it. I'll dismiss it, no problem. We'll have it on 16. We'll dismiss it on 16. Yes. Have you filed an amended cost title?
Yes, lordship.
Huh?
Yes, lordship.
And now what about the respondent number 6, 7, and 8? Notices have been issued to them. Anybody appearing for 6, 7, and 8?
Yes, your lordship.
You are appearing?
No, my senior is appearing. He's on his way.
You are standing for 6, 7, and 8?
Yes.
Okay. What happened? Do you want to file an affidavit here or not?
Lordship, I don't have the instructions. He's here.
Mr. Doctor, you are appearing for 6, 7, and 8?
For
No,
the
younger doctor.
For the PNB, your lordship.
PNB, Punjab National Bank.
Yes.
Any affidavit you want to file or records you produce? What do you want to do? It's a departmental proceeding.
Departmental proceeding. I'll
It's
produce
been
the
delayed
record.
for a long time now.
Yes.
2014 onwards. You get the records.
Yes, I'll get the record.
Oh, we'll finish it off. When?
Any date, your lordship.
You tell me.
Date.
Mr. Doctor, this is department proceedings.
Yes.
Now there is no question in filing an affidavit or something. You
Affidavit
produce
is
the
not-
records, we'll finish it off.
I'll procure that, my lord.
When it's convenient to you.
Date, June.
Nine.
Uh-huh. 5th.
Four
नहीं
is Thursday.
नहीं ये करो 9th June, my lord, if it is not inconvenient.
As agreed to by the learned counsel for the parties, registry to list this matter again on 9/6/2026.
Which
Mr.
bank?
S. Dr. Learned Counsel appearing for the petition, the junior S. Dr. appearing for the respondents number 6, 7, and 8 has submitted that the records of the disciplinary proceeding instituted against the petitioner in original shall be furnished to this court on the next date of listing. So, accordingly, registry to list this matter again on 9/6/2026.
Obliged, obliged, sir. No.
Mr. Sharma, what do I do?
I leave it to your lordship.
You can't leave it to me. I'll dismiss it.
Or liberty.
This is the matter, Mr. Doctor. Because
Already sufficient time elapsed.
I'll provide for that. I'll provide for that. But I can't assume jurisdiction.
Then, my lord.
Mr. S. Sharma, learned CGC, appearing for the, heard Mr. J. Sharma, learned counsel for the petitioner. Also, Mr. S. Sharma, learned counsel appearing, learned CGC appearing for the respondents. Mr. S. Sharma, learned counsel, CGC has raised a preliminary objection with regard to the maintainability of the present writ petition before this court. Also, this court, on a consideration of the said issue raised by Mr. S. Sharma, CGC finds that the petitioner was an employee of the Postal Department and has assailed the orders passed against him in a departmental proceeding so instituted by the postal authorities. This court finds that the petitioner's grievance would be mandated to be first considered by the learned Central Administrative Tribunal in terms of the provisions of the Administrative Tribunals Act 1985 as interpreted by the Honorable Supreme Court in the case of L. Chandra Kumar versus so-and-so. Also, in view of the above position, Mr. J. Sharma submits that he be permitted to withdraw the present writ petition with liberty to approach the Gauhati bench of the Central Administrative Tribunal. However, he prays that observation be made by this court that in the event of filing of such original application by the petitioner before the Central Administrative Tribunal, learned Central Administrative Tribunal, the delay occasioning in the matter be so considered by reckoning that the present proceedings were bona fidely being pursued by the petitioner before this court with effect from 9/2/2016. So I've heard the learned counsel for the parties, and on a consideration of the submission made by the learned counsel for the petitioner is permitted to withdraw the present writ petition with a liberty to approach the learned Central Administrative Tribunal. Also, in the event of the petitioner approaching the learned Central Administrative Tribunal by way of filing an original application, the delay occasioning in institution of the said proceedings, the prayer for delay occasioning in institution of the said proceedings be considered by the learned tribunal by also reckoning that the petitioner was bona fidely pursuing the present writ petition before this court with effect from 9/2/2016. Also, with the above observations, the present writ petition stands dismissed with liberty as prayed for. Send it down.
Yes. Kindly take the Minimum Wages Act.
I taken
Section 2. Section 2, my lord.
Section
There.
2, yes.
And the last date on a communication was placed before by the learned CGC, my lord. Therein, my lords, Section 2 completely, Section 2
Services come.
My lord?
Services come in now.
No. Section 2 says of their definitions that those areas of service which is established, which is by control by the central government and which is also of a company.
Are you in a service, by the way?
Hello?
Are you in a service?
No. But minimum wages, my lord, I'll suggest, my lord.
Minimum wages, what is that?
So that communication lordship has it.
Well, I'm just sorry for interruption. This act has been repealed.
No, my lord, it's saved by operation of General Clauses Act, section 24.
This act has been repealed and new labor code has come from last year 25. Now,
Okay, his grievances prior to that. Let us also hear that.
That I'll
Yes,
answer.
your-
my-
which?
Section 2, dear madam.
Section 2.
It extends, my lord, lordship will see section 1 where to it extends, and section 2J of section 2, my lord, appropriate government, my lord, B, lordship will find B, there's 1, Roman 1.
Okay, schedule employment.
My lords. And then after, my lords, there is a notification of Gazette notification 2017, my lords. My lord, by this notification, areas of scheduled employment has been divided into 3 categories. A, B, and C. Where my lord will find appended therein, my lords, 2 schedules. One schedule,
Just a
my lords.
I think this one is here. Last date, somebody had produced this.
No,
This
for
was-
certain different communication was there, my lords.
একটা copy আমার কাছে রাখিবা।
Mr. Kolita will have everything. Opposite party, self party, other party, he will have. 14-2.
14
yes,
14
yes, I have it.
Yes, my lord.
Copy আছে না?
14 to, my lord, it speaks of this notification.
Please refer to so-and-so along with so-and-so, so-and-so, so-and-so. That this office was already provided gazette notification and the minimum rate of wages of so-and-so. What and what category so-and-so. You have what and what is a scheduled category in employment with a minimum wages of the person, which is being revised on half-yearly basis for those employers whose appropriate government has been defined so-and-so, so-and-so. Now you come to your notification.
Notification, lordship will see, there's a schedule, 2 schedules are there. Regarding rate, 2 schedules, my lord. One lays my lords, lays down the daily wages for part 1, my lords, without arms, area A, B, and C. Without arms, and with arms, A, B, and C. And my area has, so they have written as Duliajan, but some the other areas also there, so it will come in part C. Area category C.
Now you come to the definition of employee.
My lords.
I.
Yes. It's
Any
say
employee means any person who is employed
Which-
for hire
directly.
or reward. You are neither hired nor reward.
We are hired.
No,
No, my lords. When Assam Police is asked to provide security, Assam
that is
Police,
under a special statute. Voluntary service.
no, my lord, because only that voluntary service
Oh, my-
regarding,
oh, my lord.
no, my lord, if I do a job of protecting those,
No, you are doing it voluntarily.
my lord, that is a very,
That is not a very
no, my lords,
bad
I
big thing. That is a
respectfully
term
disagree,
of
my
the
lord.
act.
My lord, the act, where the act, what we are protecting, central assets. If Assam Police doesn't protect the central assets, my lords. CISF is there, CRPF is there, they have own forces as there. CISF is being employed, my lords. When beyond that, they want something,
Your challenge to section 10 or rule 10 was negated by
that
this
was
court.
gone, that was gone, that was gone.
So if that is gone, this is also not gone.
No, my lord, that I can interpret, my lords, because had I been confined to voluntarily protecting
Yeah,
those
because
assets,
of
my
wrong
lords.
court. This
My lord.
court may not have that level of appreciation.
No, this court has everything, my lords. So,
Yes, Mr. Dr. What do you say?
Well, these are of no consequence to the present case. Because so far as the section 10 is there, We have to abide by that. And first, the reference.
He has raised a very interesting point.
Yes, but then
We consider.
it has no application to the facts of the present case.
Okay.
And our employment, their employment is also not scheduled employment.
Cannot be.
This must have a relationship with the scheduled employment. Then only perhaps it could have come.
The central government itself says after perusal of the writ petition and documents that I fall within this. It's not my case, my lord. It's their stand, my lord, through that communication lordship is holding.
That is an interpersonal communication.
No, but it's Quadi brief, my lords. Quadi brief that has been given, my lords. Had I been confined to protecting those assets which are of state or by police has given me. When Oil India goes to police, says protect me, they come to us.
The doctor would say that this is nothing but a voluntary service. For that, you are getting an out-of-pocket expense. Section 10 is the main provision,
Voluntary,
which was put to challenge.
My
And
lord,
that says no remuneration.
my lords.
So if there is no remuneration, Minimum Wages Act will not come in.
My lord, that voluntary word, if interpreted otherwise, my lords, will only come to their rescue.
You
if it's
get a better interpretation,
My lords.
get a authoritative interpretation from the higher forum.
My lords. No, lords, I'll try here only, my lords. And what? My lord, there is some other offensive he's trying to catch me on the left or right flank, my lords. He wants to deviate me from there.
You don't even look at him, it's dangerous.
Yes, my lords. Just before the matter was called, he takes me to tea.
That is still pending, Lord.
And depriving me.
You be careful.
My lords, if the central government comes up with whatever letter they content they have given, my lords.
Central government, forget it.
No, because,
I had enough.
my lords.
I have enough material.
And that apart, but that voluntary thing cannot be used against me, my lords. Because the nature of services has to be looked into. If had been the assets of the state or the Assam police assets, I have no quarrel. Okay, it's voluntary. But you are taking me out there, using my services as in a different footing, and you say
Pending,
voluntary.
Mr. Doctor. At the Learner Council for the parties at length. Hearing concluded date today. 17/6/2026.
Obligation.
দিন নামকে কাল দেবো।
দিল ফেল। তো ফেলতে হলো না তাহলে
Just write down the names also.
Obligation.
No, delivery.
In that case, I'll just, as a last straw of hope, my lords, I have this Nihal Singh's case.
Nihal Singh, that Home Guards.
Yes, madam.
Home Guards come under a different setup altogether.
No, whether these services are used at that time also. They'll say like, no, your SPOs will treat you like that.
You do one thing.
My lord?
You're not Home Guards, are you?
No, I'm trying to get
So
something else.
go and pursue that Home Guard thing. You get your services, come to me, I'll pass Nihal Singh in your favor.
My lord. All right.
The very conduct is suspect of the petition. The person represented.
Proceedings are there, my lords.
Will, at least in the writ court, there will not be a proceeding now, after 17. Higher forum, I don't know.
Higher read forum.
I don't know.
All right.
হয়েছে তো আরো দিবা কিবা
Where is Mr. Bora? Yes, implemented, done.
Yes, my lord. I can do.
So that period has been regularized, my lord.
Where is this order dated 21/5/2015?
At
Mr.
page
Stocker?
95.
Huh?
At page 95 of my report.
And done.
My lord, regarding that, my lord, retrospective effect.
They have given you.
Yes, my lord. But regarding my lord, page 95, they have, my lord,
95, what has happened, I'll tell you. That is what exactly we were asking. The period is 6/2/2006 to 8/5/2013. That is MHO, senior MHO.
yes.
Now, the next promotional post is SDMO, SDM and HO. Now, that was from 26/8/2014 to 31/5/2014.
Yes, ma'am.
Now, 8/5/2013, this ends. There is a gap. And then 26/8/2014 to 31/8/2014. Now they have filled up that gap. They have said that the promotion to senior MO medical officer would be from 6/2/2006 to 25/8/2014. So next would be 26 onwards would be the next one. We'll say that the consequential orders, revision of pension and the benefits be released to you within a particular time frame. That's all.
That is the one aspect, my lord. The
What
other,
is the other?
my lord, the other aspect is that page 95, my lord. The next below rule, my lord. Even the junior is one Hiteshwar Gogoi, my lord. I am from 83 and 86 base. My regulation was done on 86. And Hiteshwar Gogoi, my lord, at page 1 to 23, if your lordship come to serial number 417, Hiteshwar Gogoi.
When did you retire?
I retired on 31st of May 2015, my lord.
And when was this proceeding instituted?
My lord, the show cause was, my lord, given.
No, when was this proceeding instituted before this court?
In the year 2016, my lord. Retirement getting?
Gradual.
Okay, what do you want now?
My lord, after careful consideration, always the governor is pleased to allow retrospective promotion in respect of Dr. Mohan Suikia to the rank of senior MNHO under next below rule with effect from the date of promotion of his immediate junior, Dr. Hiteshwar Gogoi. I am from the base of 1986 and he is from.
You show me.
Yes, my lord. My appointment letter, my lord.
So this order is not correct.
My
You
lord,
have challenged this order.
partially not correct, my lord.
No,
Because
where is your prayer? Show me, let me see your prayer. This is the first writ petition you have filed before this court?
Yes, sir.
Huh? So come to page, prayer number A. Mr. Bora, you can take your seat. Yes, ma'am. Page 22 onwards.
Yes, ma'am.
Right?
Yes, sir.
The prayer is directing the respondent number 1, 2 to retrospectively promote the petitioner as senior medical and health officer with effect from
12/4 to
12/4/94. Or at least
31/3/1997.
with effect from 31/3/1997. And SDMO,
from 22/1/2007
or at
at
least,
least 12/11/2007.
okay. Now tell me, why the delay?
Delay, my lord,
94, first one. You filed the petition in 2016. How do you explain this delay?
well, from the very initial period, I have filed the, my lord.
Your representations will not extend your limitation. So now your prayer that you want promotion from 1994, justify that.
My lord, to 1997, my lord, my juniors who
Okay,
are
fine. Juniors superseded at that point of time. Your grievance starts from there. What made you wait till 2016?
and there is some, my lord, fault,
2016.
my lord, yes, my lord. I agree, my lord, there is some fault, but I have, my lord.
Now we are
because-
going to consider the matter and merit, and even that order we are going to interfere.
Because at that time, my lord, I have also, my lord, due to that departmental proceeding, my lord.
Where? Show me. What departmental? When was it instituted? When was it completed?
It was, my lord.
That may give you an explanation for delay. Show me that.
That is at, my lord, page.
Tell me the date of the show cause notice.
Delay, my lord, I have explained, my lord.
No, no. Where is that departmental proceeding?
Procos was, my lord, at page 61, my lord.
Date.
Date is, my lord, 22/1/2001.
So this 22/1/2001.
One, my lord.
So this show cause has not prevented your promotion in 97. This cannot be held to have delayed your promotion or kept your promotion in seal cover in 1997.
Yes, my lord.
So 97 to 2001, what were you doing?
There is a, my lord.
If your juniors have been superseded you in 1997, your grievance arose then. So you cannot wait thereafter. 2001 is prospective. Departmental proceedings don't have a retrospective effect. And when was it concluded?
My lord, it's completed, my lord, in the year 2012, my lord, after 11 years, my lord.
Okay. When completed?
On 5/7/2012.
Where is that order?
That order is at page 83, my lord.
5/7/2012, page 83.
Page 83, my lord, annexure 28. It took, my lord, 11 years, my lord.
Okay, this can be a prayer for your subsequent promotions, but this cannot be the reason for not approaching this court at that point of time with regard to promotion as SM subdivision medical of
97. my
medical
lord.
and health officer.
Yes, my lord.
Senior medical and health officer.
Thereafter, my juniors are promoted, my lord, that during this, my lord, court.
97 your juniors were promoted.
90
If it is next below rule, 97 is the junior promotion. So your grievance is from 97. Explain the delay, take the order. Where is your explanation, the writ petition?
At page, my lord, para 32, my lord.
30?
Para 32, page 22.
32.
Para 32, my lord, page 22. That there is no delay in filing the writ petition in as much as the impugn order was issued only on 21/5/2015. There is just a couple of days before his retirement. After his retirement also, he pursued the matter following issuance of
This
the
is only with regard to your regularization. That is done now. For me, the delay with regard to 1997, 1994, 1997. You sleep over your rights,
Yes,
wake
ma'am.
up one fine morning, come here, will not. And tell me, how can you assume charge after retirement from 1997? Have you assumed charge after the impugned order?
And thereafter, after 15 days, I was, my lord, retired.
So you did not assume charge here also?
And also, my lord, their post was also, my lord, not
Not
vacant.
there. So this order was only on paper, never implemented.
Yes, ma'am.
Now, Amal Satpati, you are not entitled. I am bound by the Supreme Court decision that after retirement, you cannot assume the charge of a promotion. You not having assumed the charge here after this order, it's like a promotion order being issued but not implemented. Yes, Mr. Soka. There are others waiting.
Yes, ma'am. They have also write, my lord, various letter, my lord, at page 187 also.
187.
187 on. After my retirement, they wrote, my lord, this letter. I am directed to enclose herewith letter number such and such from Accountant General Assam in respect
So
of-
we will say this exercises are not to be done. Whatever pension you have got as the earlier post. Will not give you anything further because you can't assume the charge of it.
Till date, my lord, the pension is also not given, my lord.
Pension also not given. That we will provide for them.
My lord, already it has been processed. After passing of this order, my lord.
Thereafter, my lord, they have proceeded.
You're getting provisional pension?
Yes, ma'am.
So that is mitigated.
DSS has been requested to submit current status report on receipt of pension and other retirement benefits by Dr. Mohan Soikia.
You satisfy me that you are entitled from 1994. Take the order. Or follow the regularization that they have done. I will say that this order be read along with that. Within 3 months, they will fix your pay, everything, release the arrears to you. Within another 3 months, your pension and pensionary benefits will be. Think over it. Don't do it because the court has said. This is just options. But the Learned Council for the parties at some length. Mr. Bora has placed on record speaking order dated 13/5/2026. A perusal of the said speaking order reveals that the order dated 21/5/2015, modification of which is sought for in the present petition, has been modified, and the petitioner's promotion to the rank of senior medical and health officer is now directed to be so effected with effect from 6/2/2006 to 25/8/2014. So thereafter, the petitioner has already been promoted to the post of senior subdivisional medical and health officer with effect from 26/8/2014 to 31/5/2015. So the petitioner had retired from his services on
31st of May, 2000.
Services on 31/5/2015. So the petitioner in the present proceedings have prayed for retrospective effect, grant of retrospective effect to his promotion as senior medical and health officer with effect from 12/4/1994 or at least with effect from 31/3/1996. The present writ petition was instituted before this court
2nd November.
only on 2/11/2016, and there is no explanation for the delay occasioning in institution of proceedings claiming promotion with effect from either a date in the year 1994 or a date in the year 1997. The petitioner has further projected that in the year 1997, he was superseded by his juniors. However, the petitioner had not instituted any proceeding. Be that as it may, the petitioner, Learned Counsel for the petition seeks an accommodation today to reflect upon the speaking order dated 13/5/2026 placed before this court by Mr. D. Bora. I accepted registry to list this matter again on Thursday. We want to have some more time. Tuesday, next Tuesday. For further hearing. For further hearing. The speaking order dated 13/5/2026 produced by Mr. D. Bora is kept on record and marked as X for the purpose of identification. Saka, not think over it.
Yes.
Because if I have to go into it, I'll have to go into merits.
Fine.
It may be counterproductive. And Dr. Amal Satpathy, please read that. Mr. P.D. Nair is appearing for the respondent.
No, my lord, he is no longer there. Someone else is appearing for the liquidator now, right? Okay, was lost. Because the
Because I find
bank
Mr.
is
Nair's
there.
name here. He is not here, he is not in town. Some person, so he is no longer appearing in the matter.
No, he's not.
But there is no respondent, Mr. Roy.
The liquidator counsel has been appointed. I think he should have, G. Bortolo, he's not here today. But his presence would be necessary. After all, my lord, it is.
Mr. P.K. Roy, Learned Senior Counsel, is heard Mr. P.K. Roy, Learned Senior Counsel, assisted by Ms. A. Chakraborty, Learned Counsel for the petitioner. However, there is no representation on behalf of the respondents. More particularly, the respondent number 2. Also, Provident Fund Appellate Tribunal.
No, it's this is struck off, my lord. This is struck off.
On behalf of respondent number 2, there is no representation on behalf of the respondent number 2. For the ends of justice, the registry is directed to list this matter again on 11/6/2020.
11/6.
Any problem, Mr.?
No.
I got it to go.
Lordship, my senior is on legs. Can the matter be taken up after some time?
No, we rarely get Mr. Doctor.
No, I'm very sorry, my lord. Let it be 1 or 2 days.
Please give me a
That's a
whenever it's convenient.
12 or 13, Randy.
Thursday.
Thursday, my lord. 13th. Huh?
June 11th is Thursday.
Thursday, key fix. Or then probably for 12th, my lord, 12th.
12th is Friday.
Friday. Because Thursday also some
Monday? 15th?
Monday, my lord, Monday.
15th? Let it be on 16th. 16th.
16th. I'm sorry.
We get Mr. Doctor rarely this side. No, I'm sorry. So he'll also have to be given what he gives us from this side. Why are you depriving us of that opportunity? Why are you depriving us of that opportunity? Huh? Now,
Full
Mr.
paid on lordship.
Now tell me. Technical issue number 1. What is your technical issue number 1? No issue, let him come. Yes.
My lord, last instruction may be seen, my lord.
Oh, what is the last?
7/5/2026.
20?
7/5/2026, they place 1 instruction, my lord.
27/5.
7/5.
Okay.
The last page, my lord. May I read, my lord? From start with A.
No work, no pay. What is the mistake? And there is a decision of a coordinate bench that
Well-
PTC matters. Mr. Talukdar and Mr. Dotto, you know, Thor, you know about that. Some decision of
For that, my
my
lord,
Lord Justice Burua, that this will not be applicable, no areas. Ah.
my lord, for that, my lord, I have placed one Supreme Court judgment, my
Oh,
lord.
Supreme Court
The
judgment. will
guideline
come.
is there.
First
Because
is the
facts are
facts.
totally different, my lord.
First is the facts.
Facts are totally different from those cases, my lord.
Ah, this is also like pension, like your panchayat.
No.
You appoint somewhere, then you regularize. This period you don't get, you get it from here.
No,
Now show me why we will not apply the same principle here.
my lord, in the present case, my lord, he was founder teacher of one school. In those
He is
cases,
terminated.
yes.
You are claiming benefit of that division bench judgment. 15, I think. No. Writ appeal number wherein the.
My case was separately allowed, my lord.
Show me the order.
No, lord. The
Page
impugn-
36.
Yes, my lord.
Yes, Miss Chaudhary. You came too fast.
No, Lordship, I
You
was,
denied us a pleasure.
Lordship, I was in another.
No,
court,
no, you
Lordship.
denied us a pleasure to have something with Mr. Chaudhary today, Mr. Dotto today.
Lordship, on the last occasion, as per Lordship query, I have placed one document.
This is the 7526. 7526.
726.
This is contrary to what this court had ordered. This court said
Along with another
will
communication.
be given full benefit, all benefit.
Lordship,
How can you deny it?
on 7/5/2026, along with this communication, there is another notification mentioned, 2nd August 2024. I have placed before this honorable court as per queries made by this honorable court. And according to that, Lordship, 2nd August 2024.
Okay, both this
In
will go
second-
now. How can you? This is in the teeth of the order passed by this court in the earlier round of litigation. WPC number 1242. Wherein this court has said petitioner would stand reinstated in service and he would be entitled to all benefits in terms of the policy decision as above. And the policy decision is whoever received salary till 2006, particular date, they'll be reinstated. And you have paid this salary to all the people. Why not the petitioner?
And in fact, my lord, my gap periods are also regularized.
No, no, no.
Where
That,
did I get it?
Lordship,
That communication, my lord, Lordship may see.
that will answer my submission.
Oh, that regularization is for the purpose of pension.
Yes, Lordship. Not
But
for the
how
gap
can- they
period.
can, my
Lordship.
lord, say, my lord, no work, no pay.
Yes.
For that, I have placed that Supreme Court judgment, my lord. When no work, no pay will come, my lord.
In regularization, this notification specifically they have stated only for pensionary benefit. The service gap period has been
Okay, what is the
regularized.
policy of the government?
No work, no pay, Lordship.
No, no.
This is the law.
Let us see the judgment, earlier judgment, page 34. You're still in service?
Retirement,
No pension given?
pension given.
Pension given.
Yes.
How was this period? They have regularized this as
Yes.
on.
Only arrear paid after reinstatement, my lord.
Okay, but
Now I'm claiming-
notionally they have given you that benefit for that period?
Yes. Now I'm claiming only, my lord, from termination to date of regulation.
The gap
reinstatement.
That period,
Gap period.
have they fixed it notionally, like counting the increments, then fixing your pay as on the date of
That
reinstatement?
part are now only gray area, my lord, because that is not with me, my lord. But my client informed that he is getting regular pension. How they have calculated that is not.
Wait a moment. Yes, Ms. Chaudhary, anything more?
Lordship, the gap period, Lordship, he will not get anything as he has not worked at that time of time, and he has, as
Was
per
that the
his
policy of
prior
yours?
Lordship,
Was that the policy of yours when you moved the court? Now another thing. The earlier order, while directing for his reinstatement, there is another finding given by this court that the departmental proceeding instituted against him, conducted against him, totally perverse, violation of rules. So the whole thing goes. If the whole departmental proceeding which led to his termination is found to be perverse to the provisions of the rules of 1960, he was forcefully kept out. How can we deny him wages? Now, whether that period has been notionally fixed, that also is not clear. This judgment, oh, this.
Yes, my lord. Para 38. Yes, sir.
You will not be entitled to full back wage.
As per this judgment, I am entitled to full, my lord. Because, my lord, say, from since, my lord, it's more than 10 years, my lord, without any penny, my lord, he has suffered, my lord.
Now that period has to be regularized.
Already, yes.
regularized for the purpose of pensionary benefit.
No, you have regularized, I understand. But have you notionally fixed? Say, every year a man gets an increment. Say on the date, say, let us say 1/12/2008. His pay was 100 rupees. On 1/12/2009, his pay cannot remain 100 rupees. It will be 110 or 103, 104. Likewise, he gets 10 increments. Now, when you reinstated him, did you reinstate him with 100 rupees or 100 plus X, that is the variation, plus 10 increments? If you have done that with 10 increments, this court will.
That information is not written. at
That
present,
information
Lordship.
you get me. I think last time also I asked for that.
No, this thing was not.
It developed na, slowly. Laha. Ms. N. Chaudhary, Learned Standing Counsel, BTC, on the next date of listing, shall apprise this court as to whether on regularization of the period of absence of the petition. Period of absence of the petition on account of being imposed with a penalty of with a terminate on account of termination of his services with effect from 1/12/2008 to 8/2/2018, comma, the pay of the petitioner for the said period was notionally fixed and his pay accordingly was arrived at on the date of his reinstatement. So the said instruction be placed before this court, received in writing from the competent authority of the Bodoland Territorial Council on the next date of listing. Registry to list this matter again on
At least 2 weeks, Lordship.
on 9, 10, 10/6. They're not Buddhism. 10/6/2026. Otherwise, madam, we'll have to give him the full thing. There are 2 points. This you give me this instruction. Let's see how we then can cushion it up. But he is entitled to a back wage because the proceedings that was held against him, this court had already held, was of clear violation of principles of.
We'll take instruction, Lordship. Obliged.
Highly obliged.
So, Mr. Doctor, more this side, we will love to see you.
Highly obliged.
There has to be a balance between both sides.
I'm trying.
Records have you got the records?
Yes, Lord, I have the records. Lord, the other,
Not whether against others who were there
Yes.
in the
I have
poetry of Mr. Tharma,
Lordship.
were they also proceeded against?
Because I have not found, I have not been given any instruction on that.
Right? That means it's not there.
It may not be there. Let us proceed.
That was
Lord,
the specific
on this.
instruction was.
They got it.
And the other thing is that, my lord, he has not been dismissed or removed from service. The punishment imposed is, my lord, reduction of basic pay by 2 stages with cumulative effect. Whether in view of the materials on record, my lord, and the findings of the inquiry officer, etc., any interference is required, my lord.
Now let us come to the charge.
Page 26.
Come to charge number 1, D. D.
There's the
Last
officer-
line of subpara D of para 1.
Lordship.
Bank is exposed to incur financial loss to the tune of present outstanding balance of so and so, excluding notional interest. So it is around 6 lakhs odd you are losing.
Lordship.
Similarly, the other thing also, charges also allege that he had done something,
Lordship.
not following the procedure,
Lordship.
which had exposed the bank to a loss.
Lordship.
So this is very serious charge against him. Now, basing on this charge, how do you justify a penalty of withholding of 2 increments?
Lord, the answer probably lies, my lord, in my humble submission, it lies in the fact that he was not the only man in the branch or the
That
hierarchy.
is why we want you. If he is not the only man and you have not proceeded against anybody else, how will you put the
Because
responsibility?
he was the second man in the branch, and definitely, my lord, he has a responsibility in
I know,
looking
then
in the,
who is the first man?
my lord, the first man is the branch manager.
So
But
it is under his authority they are working.
yes, but here, my lord, the
Where
whole,
is the proceeding against the branch manager?
it perhaps is not there, my lord, from what my instruction is. And
You
in the,
can't, if your authorities can't tell you whether yes or no, what is
because
the?
I'm going by a no,
today?
my lord. I'm going by a no, but here
No,
the essential charge is that, my lord, his was the recommendation. And because his recommendation, my lord, here lordship will see that what has been done
No,
is that,
his recommendation again is based on some other persons going to the field getting it.
No.
They have also not been proceeded against.
No, my lord. Here, my lords, in fact, he was the assistant manager. So he makes the recommendation, prepares the file, forwards it to the branch head, my lord.
Let us see the findings of the inquiry officer.
Yes, page 38 onwards, please, Chair.
40.
Page 48, my lord, analysis of the charge of inquiry officer.
Forty-eight.
48.
The analysis he has done charge.
Every charge.
In on every charge he has done.
Yes.
And he has held maximum charges to be proved.
Proved.
And it's your discretion what you apply, what penalty you give, that is your discretion. That this court cannot say anything.
And conclusion at page 55, last paragraph.
He is still working or retired?
Retired.
Retired.
Prior to
Now, this is a case for dismissal.
Correct.
Right? Your inquiry officer has held that every charge is proved.
Lodge.
But why did the disciplinary authority climb down
Lodge.
to that of a reduction of pay by 2 cases?
And
Now,
one more.
this reflects that the conclusions of the disciplinary of the inquiry officer are forced conclusions.
That was the disciplinary authority may have gone by the circumstances of the case. And also at page 57, if one sees what is his stand, he says, if your lordship has for a minute, page 57, he says this is the reason that he gives, somewhere in the middle.
When did you retire, Mr. Sharma?
my lord, I have retired just 1 month prior to my lord. Date of retirement, my lord.
2020, January.
Thirty-first January 2020.
31st January
2020.
And probably that also, my lords, have been there in the mind of the. I mean, he says in his reply, my lords, before the disciplinary authority that, sir, due to tie-up agreement MOU signed by then chairman of our bank with different dealers of tractor and auto rickshaw, we had to follow up numbers of loan proposals within a short period, for which some irregularities may occur through oversight, but branch had sufficient time to inform me to rectify those. We say that because, in other words, because of the pressure of work, number of proposals were there.
That is no defense.
No, that is there. So in effect, my lord, he has admitted that there was some oversight. There were, but probably, my lord, in this case, there is no aspect of misappropriation or defalcation of the bank account. That and verge of retirement, that also lordship will perhaps see. 19th of December is the order of penalty and 31st January is to retire. So that may be one reason, my lord, that.
Yes, Mr. Sharma.
And apart from that, my lord, no proceeding has been initiated, although my lord, findings of the inquiry report that all the officers in my lord responsible for sanctioning the loan is equally responsible. That was the finding of the inquiry report. No, my lord, nothing has been done against any other officers, including the branch manager. And apart from that, if your lordship see the impugned order, page 59, the past record of the petitioner has been taken into consideration while imposing the penalty, but that there was no charge, nothing.
Mr. Sharma, this past record here,
my lord,
in all probability was taken in your favor. Otherwise, this is not the penalty that was called upon. It was a case of dismissal. Right, wrong? That's a different thing. But from the inquiry report, the materials that have come on record, this was a case for dismissal or removal. Nothing.
But why, my lord, for me only?
Now,
Why?
where is that plea taken by you before the authorities? In your appeal, have you taken that plea? We want Prasanta Kumar Sharma to take that plea, not Mr. Dharmendra Kumar Sharma to take that plea.
There's a reply at page 34.
50? No, not the reply. Your appeal.
Reply against the third, my lord.
Where is that?
Page 34.
34.
This specifically mentioned.
Where? Show me.
Because I was not the branch head having discretionary power of.
Kindly
sanction of
read the whole paragraph. And thereafter you want to argue further on.
A letter number so and so, you have stated that I have grossly violated the regulation 18 and 20 of the AGVB Officers and Employees Service Amendment Regulation 2018, which attracts penalties under Regulation 39(1)B of the said service regulation. As per my prudence, I think that this regulation is not applicable in my case because I was not the branch head having discretionary power of sanction of loan and advance of the branch, but to carry out the order of my superior for interest of the bank. As a loyal officer of bank, I had to process the loan proposal as directed by the branch head and accordingly complied his order and placed proceeding.
Mr. Sharma, read this very carefully and place processing note along with other papers to the branch head for his decision.
For his decision.
Now, the allegation against you is not of sanction of law. It is with regard to the manner in which you had collected the documents and placed it. Now come to the charge.
I must say one thing, in his memo of appeal, he has said that other officers have not been prosecuted. That is there at page 63.
We'll come to that.
That I must say.
Now you come to the first charge.
Charges are similar in nature.
No, you come to the first one. All tractors only.
Tractors, all tractors.
On your recommendation, a loan for purchasing of a tractor was sanctioned by the then senior manager of the branch in name of so and so. The irregularities. Margin money of 41,000 was not deposited in the marginal deposit account. Processing was done with coverage of 64 lands, whereas no land document valid lease deed of land found in the loan documents. Document audit was not done. As an officer of the branch looking after the credit portfolio, you did not look to post disbursement monitoring follow-up measures as required, for which the loan account has turned NPA and it is a case of quick mortality as per IRCA norms. Bank is exposed to forget that. Now, the essence of the charge is you had not done your job as a credit officer. What do you call that? Credit officer. Credit portfolio. Looking after the credit portfolio. So, the further steps that was taken by the authorities of the bank resulted in the account being NPA. And you have admitted that.
Is it not?
You have admitted that.
Is it not the responsibility of the higher officer?
No, it is not the sanction of the loan, Mr. Sharma.
While sanctioning the loan, my lord, everything.
Okay, he has done that. Fine, no problem. But have you done your job properly?
If it is assumed for a moment that I have.
No, I did not assume. You have written yourself that along with a note, along with other papers to the branch head for his decision. So your papers were not
scrutinized by the branch manager, my lord. Without
you both are in cahoots, maybe.
My lord, why, my lord, that has been, my lord, done in.
Have you?
Me only.
Okay, have you cross-examined any of the witnesses on this point?
That I have to go to the record.
Yes, Mr. What is the material of cross-examination by the, has he raised any such query?
The minutes are here.
You go through that, find out, because you will have to establish that the documentation made by you was perfect and the thing was at the fault of the branchman. Then we can take you out. Otherwise, if your processing is done, you have done, it's not correct.
Let me go through the record, my lord, and lordship may take up.
Mr. A. Ganguly, learned counsel representing the respondent, in terms of the undertaking given by him on the last date of listing, has produced the departmental proceeding file along with the containing also the the depositions of the witnesses. Mr. D. Sharma, learned counsel appearing for the petition, submits that he be granted a week's time to peruse the depositions of the witnesses and make his submissions thereafter. I accepted. Registry to list this matter again on when?
9th of January.
9 June, 9/6. Done.
Published.
Of further hearing.
In this case, I pay for accommodation for two.
That is only what we have been doing on last day also.
No.
Oh.
Senior left this code, Lordship.
Huh?
My senior has bought left this code, due to some urgency. But he was in the code, Lordship.
Pleading complete.
Complete, Lordship. Pleading complete.
Mr. Chaudhary has serious objection.
Lordship, but the punishment which imposed,
You want to argue on merits? You want to argue on merits?
No, my lord.
He is having serious objection.
Break also, my lord.
Having so much objection.
Counter attack of this, Lordship. For some other.
On the prayer of the Learned Council, on the prayer made, prayer is made on behalf of Mr. S. Bothakur, Learned Senior Counsel, for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by Mr. Beach, Learned Counsel, appearing for the respondents. You are appearing for all.
Warehousing Corporation.
For the respond number 1 and 2. Both
1 and 2.
Also, accordingly, registry to list this matter. When, Mr. Chaudhary? When should I take it up? Discretion is yours.
June. In June, any day. Not on 3rd of June.
On
Except 16.
18, 6, 20. That Navy,
My lord, yes,
brother Navy,
my lord,
compassionate
my
appointment.
lord. That is, his,
I think I have heard it. Today I kept it for passing orders. You are. The compassionate appointment can be considered only under a scheme.
my lord.
They have so beautifully, they are accounts people, they know how to put figures properly. They have put that figures, come to a conclusion that it is more than 75%.
That is, my lord,
That is also considering the income of the brother of the petitioner. Now you have very vaguely made a statement somewhere in the reply, and he is no longer staying with you. He is already abandoned you. What is the material? If the mother of a armed forces personnel is abandoned by that armed forces personnel, the armed forces will not allow him to breathe easily. You get my point? If that is the allegation, your brother would be in trouble. If I write that down and send a copy, mark a copy to your Navy people, they will do the needful then. So let us not go into that. Scheme is there. You don't come under this scheme. That's the end of the matter. There is no right of compassion. Yes. Yes, Mr. Consul.
Sir, Your Lordship, that was our contention. So they are eligible for the gratuity in lieu of the compassionate appointment.
And you have given him?
No, we haven't given them yet because they have not claimed it now. They have filed this writ against us, against that disqualification order that we passed.
Oh.
Now we'll pay them.
Pay them immediately. Yes, sir. Heard Mr. K.U. Ahmed, Learned Counsel for the petitioner. Counsel, what is your name?
J. Borua, my Lordship.
And also Mr. J. Borua, Learned Standing Counsel, State Bank of India, appearing for all the respondents. The petitioner in the present petition has prayed for a direction upon the respondent authorities to consider his case for appointment on compassionate grounds in pursuance of compassionate grounds. Also, as projected in the petition, the father of the petitioner. What is the name of your father?
My lord,
Madhuram Nath. while working as a guard. Where?
My lord, Rota SBI branch.
Guard at the Rota branch of the respondent number 1 bank, comma, had died in harness on date
14/2/2022.
14/2/2022. Also, the petitioner thereafter submitted an application for appointment on compassionate grounds in terms of the scheme in vogue in the bank in this connection. Also, have you approached this court earlier? No, this is the first time.
First time. This is my lord
The
initially.
petitioner, was it rejected? Your application was rejected?
My lord.
Which is the order?
My lord, the first one was returned by annexure 15, subsequently rejected.
Where is the
67.
rejection? Huh?
67 is the rejection order.
Also, the case of the petitioner on being considered by the respondent bank, comma, void communication dated 12/3/2025, the application made by the petitioner for appointment on compassionate grounds came to be rejected, holding that the monthly income of the family of the father of the petitioner was higher than 75% of the last drawn gross salary of the deceased employee. Also, it was further projected therein that the deceased employee had an unmarried son who is employed and was drawing a gross salary of rupees 46,547 as per the proposal submitted earlier. Accordingly, the claim of the petitioner for appointment on compassionate grounds was rejected and the proposal was returned with an advice to submit the proposal for payment of ex gratia lump sum amount.
Yes,
Mr. K.U. Ahmed, learned counsel for the petitioner, has submitted that although the brother of the petitioner is working with the Indian Navy,
my lord, CIS,
CIS, working with the CIS, Central Industrial Security Force, comma, he had already separated from the family of the petitioner and has not been providing any maintenance amount, not providing any amount from his salaries for the maintenance of the petitioner's family. Accordingly, he submits that the said salary drawn by his brother was not permissible to be so computed for the purpose of arriving at the total income of the family of the petitioner. Also, Mr. Ahmed submits that in the event the salary drawn by the brother of the petitioner is removed from the purview of the is removed and the calculation made, it will be found that the petitioner is entitled to be considered for appointment on compassionate ground in terms of the scheme holding the field. Also, per contra, Mr. J. Borua, learned counsel for the learned standing counsel, State Bank of India, appearing for the respondents, by drawing the attention of this court to the revised scheme for compassionate appointment in State Bank of India, has submitted that the said scheme mandates that the compassionate appointment will be sanctioned to the dependents of the deceased where the monthly income of the family is less than 75% of the last drawn gross salary calculated in terms of the parameters set out therein. He submits that on a calculation being so made, comma, it submits that on the application made by the petitioner being processed, comma, The inquiry made thereon, had revealed that the petitioner's brother was employed in the Indian Navy.
Isn't it Indian Navy? Yes.
My lord,
Indian Navy.
Indian Navy, my lord.
Indian Navy, they put CISF now. Indian Navy, and was also drawing a gross monthly income of rupees 46,547. In terms of the scheme, the said amount being required to be also computed as the family income of the family of the deceased employee, the same was also reckoned. And on reckoning the same, along with the other income received by the family, it was found that the gross income of the family exceeded by 75% the last drawn salary of the petitioner. The learned counsel for the bank has submitted that the payslip brought on record by the petitioner is for the month of February 22.
Yes, my
Right?
Yes, my lord.
February, where is that payslip?
Was there, not sure.
It is, my lord, annexure C, my lord. Affidavit in counter affidavit. Page 108.
108, my lord.
108.
Yes, ma'am.
Where do I get the month? January 22.
Payslip January?
No. He has brought on a record February. Is for the month of February 22, and submits that this is father of the petitioner having died in harness on
14 to 20.
14 to
14 to 2022.
14
to
2022. The salary for the month of February 2022 was not calculated for the whole month, but proportionately for the period the father had so served. He submits that the amount take-home salary as reflected therein cannot therefore form the basis for the calculation required to be made. Mr. Borua has referred to the payslip of the petitioner for the month of January 2022 and has submitted that the said payslip and the amounts take-home salary and the gross salary as reflected therein was taken as the basis for the calculation made for ascertaining the eligibility of the petitioner herein for being appointed on compassionate grounds. Also, in the above premises, Mr. Burwa submits that the petitioner's family is entitled to an ex gratia, right?
Yes, ma'am.
In ex gratia amount in lieu of compassionate appointment, and the same was not released to the petitioner's family in view of the pendency of the present proceedings. I've heard the learned counsel for the parties and perused the materials available. It is a settled position of law that a compassionate appointment can be directed to be considered only within the parameters of the scheme, so formulated for the purpose. In the case of hand, for appointment on compassionate grounds, a scheme is already prepared, was already invoked, and the same was subsequently revised. The application submitted by the petitioner was considered under the revised scheme for compassionate appointment in State Bank of India. Clause 7.3 pertains to the financial condition of the family of the deceased employee when an application for appointment of a family member is on compassionate grounds is so made. Clause 7.3 mandates that compassionate appointment in such cases would be sanctioned to the dependent of the deceased employee only when the monthly income of the family is less than 75% of the last drawn gross salary, calculated in terms of the parameters set out therein. Also, applying the set parameters, the respondent authorities had found that the salary, gross salary, which as noticed herein above, was taken to be the salary drawn by the petitioner's father during the month of January 2022, was found to be more than 75% of the family income of the petitioner's family was found to be 75% more than the last gross 70 was found to be more than 75% of the last drawn salary. It's 75% of that.
Yes, ma'am.
Also, it is more of correction. The respondent authorities, for the purpose of arriving at the family income of the family of the father of the petitioner, had also reckoned the salaries drawn by the brother of the petitioner as a member of the Indian Navy. Also, it is with the inclusion of the salary drawn by said brother of the petitioner that the computation of the family income of the family of the petitioner was so made. Also, the petitioner has made a submission the petitioner in the present writ petition has projected that although his brother is working in the Indian Navy and drawing a gross salary of 46,547, he had left the house and was not providing any help to the family. The said statement is not supported by any further documents brought on record. So, the mother of the petitioner being alive, mother is alive?
My lord.
It is the bounded duty, mother being alive and the, should I write it? It may create problem for you. Accordingly, the said contention of the petitioner would not mandate an acceptance from this court. This court finds that the income of the family would also mean the income drawn by each member of the family. The brother of the petitioner is to be deemed to be a member of the family, and accordingly, the inclusion of his income in the computation made with regard to the family income of the petitioner's family is in no way erroneous. Also, in view of the above discussion, this court having found that the rejection of the case of the petitioner, claim of the petitioner for appointment on compassionate grounds being so made within the four corners of the scheme in vogue, the rejection would not mandate interference by this court. Having drawn the said conclusion, this court directs, this court refers to the submissions made by Mr. J. Burwa, Learned Counsel for the respondent number 1 bank, to the effect that the petitioner's family is entitled to compassionate
gratuity in lieu of
entitled to gratuity in lieu of compassionate appointment, and the same was not being released only on account of pendency of the present hospital. It is directed that the said gratuity in lieu of family pension be released forthwith, be released within a period of 1 month from the date from today to the person who is presently in receipt of pension with regard to the services rendered by the father of the petition. That means mother. So, with the above observations and directions, the present writ petition stands disposed. Anything more?
No, ma'am. Obliged.
My lord, on the last occasion in the mediation.
How are you now? You don't look to be perfect. You should not have come. You can come online. Why are you taking the trouble of coming here? Come online, get well, then you start. You're not a small kid now, are you? Yes, tell me.
In mediation, the petitioner has told that before 1 year almost, the petitioner died. So after that,
The petitioner is no more.
petitioner is no more.
No substitution has been.
No substitution.
Where do I get that? Do I get
Please get
anything?
from the mediation. From the mediation.
Now you want to pay.
Lordship, we have already filed our affidavit, Lordship. There it is stated that it's filed earlier in 2022, Lordship. It says that no proper document was submitted.
No, here the mediator says, come to the mediation order. The respondents appeared in the mediation center and agreed to pay the payment of the petitioner. Then she asked the counsel to talk with his client. Who is the counsel? Okay, we'll say that this matter is abated. No, we'll close it. None appears for the petitioner on solved. You are for?
I am for Animal Husbandry and Veterinary Department. Respondent number 4. Wow.
You are the main man.
Yes. 1,
But Miss M.M. Kotoki, learned
1, 4, 5.
standing counsel,
Six.
Animal Husbandry and Veterinary Departments, appearing for the respondents number 1, 2, 4, 5, 6, and 6. Ms. Kotoki, by referring to the report of the mediator dated 12/12/2025, has submitted that therein it was that during the process of mediation, it was revealed that the petitioner had passed on during the pendency of the present proceedings. So, there is no application submitted by the heirs of the petitioner, original petitioner, for substitution, for substituting themselves in place of the original petitioner. So, accordingly, this court is left with no other alternative to hold that the present petition stands abated. Accordingly, the present petition stands closed on being abated. If they come back, we'll see.
Obliged.
This is a matter pertaining to selection and appointment to the post of Gaon Pradhan.
This is I am for respondent number
Leading
4.
to Lordship, charge sheet being filed against the members of the selection committee. All the 4 members of the selection committee, they were arrested and put behind the bars. And Lordship, since CM's vigilance case, the trial is still going on. And subsequent to that, Lordship, charge sheet being filed, he was placed under suspension and put behind the bars. Now, maybe because of some default, Lordship, he was again reinstated. So this selection cannot be survived, and he applied for a different lot and appointed in my lot, Lordship. His application was for some other lots, but shown to be selected and appointed in my lot, Lordship, where I have applied.
Got it.
And this arrest and other things were widely reported in the media, Lordship. And the Deputy Commissioner, Lordship, she had applied for pre-arrest bail that was denied by the Honorable Court.
This is Thubri.
South Salman.
South Salma.
Lordship may kindly see page 56, Lordship.
Page 92, para 17.07, is this the board?
Yes.
Huh?
Sorry,
Is
Lordship.
17.07, page 92, is this the board by which the selection was made?
Yes, Lordship. Yes.
See first and tell me.
Yes.
17.07, page 92. Of the writ petition, I suppose. No,
17 point?
17.07.
Yes, Lordship. 17.07.
Yes, Mr.
Yes.
I am for the private agencies case. There is a objection is there, alternative remedy is there. The appeal provision is there against the selection and appointment of the Gauhati. And moreover, today's arising the same selection list, 3 cases listed by court number 22. All the cases disposed, direct the petitioner to approach the appeal provision directory also. 3 cases, item number 6, 7, and 8. My learned
Here,
friend has
let
appeared.
him talk about this case, Lordship.
The appellate authority is the director of
Director,
land.
land revenue.
He's not the, he's the additional director was arrested. Or the director was arrested.
Director, land revenue and service.
Land record.
Records
So where
and
will the poor man go? Huh? We have been getting that news that he is also placed under arrest. Huh?
It is same.
The addition.
That is another person.
That is not the director.
No, no.
Then it's okay.
Director.
Yes, Mr. Das.
And also,
The
this
appeal
could similar
provision is
also
there. Go
there,
execute,
reported
go and
judgment,
avail the appeal.
reported judgment
Is
also.
there an interim order here?
No, Your Lord. No, Your Lord. We are serving it. And I have filed affidavit that is denied the allegation that we have applied for that.
Your this selection is doubtful. But it's too early to say that today. Yes, Mr. Das.
Lordship, although Lordship, the appeal authority.
No, when a
but is
statutory
there-
appeal is there, this will require verification of facts.
Facts.
And that facts can be verified by the appellate authority only. Whether there was something, whether there was nothing, we'll have to do it on the basis of affidavits. He can do it on the basis of evidence. You get to cross-examine. Yeah, we'll direct within a period. They'll do
If
it.
the respondents can produce the records, Lordship can very well.
Why should we do that? Why should we go into that?
One judgment is there, Lordship.
Which judgment? Oh, my judgments are there. I have my own.
Godrej Sarah Lee versus exercise and.
That is the old one.
Lots
Now
of
the point, the regulation that is there, it clearly provides for an appellate forum. Earlier it was the government, now it's the director.
Director.
Appear.
Lordship will appear, Lordship may kindly indicate. Lordship may kindly indicate the facts. Lordship.
No, we'll say that we are granted liberty to withdraw this petition with, you are granted by permission to withdraw the petition with liberty to approach the director, appellate authority within a period of 1 month.
The writ petition which have been Lordship sent today, facts are narrated, then it was sent, then my interim order was also continued till disposal of the appeal.
There is no interim order here.
Yeah, yes. But one in 3 cases were also sent back to the director. In 2 cases, interim orders were there. In 1 case, interim order was not there. My learned friend also appeared in the same case.
Okay, you want me to send it now? Lekha. I heard Mr. SK Das learned counsel.
By narrating Lordship, at least Lordship the facts, few facts.
We will not prejudice the appellate authority. You file an appeal, he will consider. Why should I prejudice him? Not do that. Heard Mr. SK Das learned counsel for the petitioner. Also heard Mr. S. Ali.
S. Islam.
S. Islam learned.
For respondent number 4.
For the.
Respondent
Mr. C.K.S. Borua.
Number 2.
2. And who is appearing?
And for respondent number 2.
For respondent number 1. Pending counsel, revenue and disaster management. And Mr. C.K.S. Borua, learned. For 1 and 1. C.K.S. Borua, learned government advocate for respondent number 2 and 3. 2 and 3, selection committee, 2 and 3. And Mr. S. Islam, learned counsel for the respondent number 4. The petitioner in the present petition has presented a challenge to the selection and appointment of the respondent number 4 as the Gaubura of to the selection and consequential appointment a selection of the respondent number 4 as the Gaubura of lot number 54 under South Salmara, Mankacha district. So the respondent number 4 was appointed as the Gaubura of lot number 54 by an order dated 23/12/2020. The petitioner's basic allegation with regard to the appointment of the petitioner is that the said appointment was tainted with corruption inasmuch as was so made by what is your allegation basically?
Lordship, page 56. Page 56 of my writ petition, Lordship. The serial number 323 Jamal Hussain, and Lordship serial number 327 is the respondent who has been appointed. Clearly, Lordship, he has applied for lot number, Lordship.
Has submitted that the respondent number 4 was so appointed, not against the lot for which LATA he was so he had so applied, but for a different lot. He submits that the said action was taken by the respondents only on account of the manipulations made by the selection committee members in the matter. He submits that criminal proceedings have been instituted against the candidates, including the petition respondent number 4 hearing, as well as the selection committee members, and a charge sheet in this connection has already been filed.
Page 95, Lordship.
Has already been filed.
Page 17/17, Lordship.
And the same is pending before the competent, is pending before the has already been filed before the competent court of law. So accordingly, he submits that the appointment of the petitioner of the respondent number 4 being not one made through a transparent process of selection, the same would mandate an interference from this court. Per contra, the learned counsel for the respondents have submitted that the issue raised by the petitioner in the present writ petition in terms of the executive instructions under the Assam Land Revenue Regulations 1986 would be mandated to be so raised before the designated appellate authority. Also, by referring to the provisions of clause 162-C, it is submitted by the learned counsel for the respondents that an appeal against the order of appointment, suspension, and dismissal of a Gaon Pradhan by the district commissioner or by the principal secretary of the autonomous council shall lie to the director of land records and survey Assam within a period of 60 days from the date of receipt of a copy of the order of appointment. So, accordingly, it is submitted by the learned counsel for the respondents that the present writ petition would not be maintainable and the petitioner would be required to approach the appellate authority by instituting an appeal against the assailing the appointment, selection and appointment of the respondent number 4 as the Gaubura of the lot in question. I have heard the learned counsel for the parties and also perused the materials available on record. Clause 162C of the executive instructions under the Assam Land Revenue Regulation mandates that an appeal would lie against an order of appointment of a Gaubura before the Director of Land Records and Survey Assam. Accordingly, further in the present writ petition, the issues raised by the petitioner would require a factual determination, which may not be permissible to be done in a writ proceeding at the first instance. Accordingly, it is advisable, accordingly, the petitioner would be required to approach the appellate authority by way of filing an appeal, raising the issues so raised by him in the present proceedings, while assailing the selection and appointment of the respondent number 4. So accordingly, the petitioner is directed to file an appeal before the Director of Land Records and Survey, Assam, Surveys, yes, Assam, within a period of 30 days from today. In the event of filing of such appeal by the petitioner, the Director of Land Records and Survey, Assam, shall proceed to consider the same on merits by reckoning the fact that the petitioner was bona fidely pursuing the issue before this court in the present proceedings since the year 2022. So the appeal that is now directed to be filed by the petitioner be not dismissed on the ground of limitation and be considered on its merits. The consideration that is now directed to be made with regard to the appeal that would now be submitted, if submitted by the petitioner, would also require the director to hear all the concerned parties, including the respondent number 4, after issuing due notices to them. With the appeal be considered and disposed of within a period of 3 months from the date of institution of the same before the appellate authority. Will do? So it is also open for the petitioner to make a prayer for an interim relief before the appellate authority, and the same would be considered on its merits by the appellate authority. So with the above observations and directions, the present petition stands. Mr. Das don't seems to be very happy.
Lordship, these are apparent illegalities, Lordship. So much of corruption and some same record will come.
There is a requirement of institutional uniformity.
All are there, men also.
I can't say many things sitting here, so it's better I keep my mouth closed too. Mr. Islam knows it better. Any urgent matter, interim order to be extended or something like that?
My lord, the matter has been in progress.
Which one?
Item number 19.
What is your name?
S. Jamal. S. Jamal.
You are there in the case?
No.
Huh?
No.
Then why are you making that submission?
Advocate P. Gogoi has instructed me to.
Mr. N?
P. Gogoi.
Your name?
S. Jamal.
S. Jamal, Learned Counsel, on appearing on instructions from Mr. P. Gogoi, Learned Counsel for the petitioner, submits that the issue raising in that the present petition has been rendered infructuous during the pendency of the present during its pendency before this court. The issue involved in the present petition has been rendered infructuous during its pendency before this court. So, in view, the prayer is not objected, submission is not disputed by the Learned Standing Counsel or the Learned Mr. H. Borua, Learned Standing Counsel, Finance and Taxation Department.
On behalf of B. Chaudhary, my lord.
Oh, you are also B. Chaudhary. H. Borua appearing on behalf of Mr. B. Chaudhary, Learned Standing Counsel, Finance and Taxation Department. In view of the above, the present petition stands closed on being rendered infructuous. Yes,
My lord, item number 28, interim order may be extended, my lord.
Sure.
And another thing, in fact, Mr. Bhattakur informed me that he'll also be making a mention for this case.
He's gone, Mr. Senior Counsel Botak.
Yes.
He is left. That there was some mention made.
So
with him.
item number 28, interim order may be extended, my lord.
28. But Mr. S. Chakraborty, learned counsel for the petitioner, also heard Mr. Kulta, you are there?
No.
And Ms. Udas, learned counsel, learned additional senior government advocate appearing for the state respondent. Also, as agreed to by the learned counsel for the parties, registry to list this matter again on
25th of June.
25/6/2026. Interim order planned earlier to continue till the next date. Yes.
In respect to item number 37, Lordship,
Ah.
Lordship, the matter was earlier referred to the mediator, Lordship, and the registry has received the mediation report, Lordship. The matter was settled, Lordship. May I fix a date?
37.
37, Lordship. I am for the petitioner.
Who is for the, Mr. Halu is not here. On the
Already-
prayer of Mr. K. Kolita, learned counsel for the petitioner, registry to list this matter again on
Registry-
8/6/2026. Yes, Mr.
23, my lord.
Huh?
23, there is an interim order that. will be
23.
amended. Yes.
Okay. O. Laskar. I heard Mr. O. Laskar, learned counsel for the petitioner. Also, and Miss E. Sharma, no, U. Sharma.
Lordship.
Same thing.
No, Lordship, you Sharma.
No. B. Sharma is also same. U. Sharma, learned government advocate appearing for the respondents. Why? What is the problem? You have filed your affidavit.
No, Lordship, we have not received parawise comments only, Lordship, so I will pray for
They are ignoring you.
2 weeks
And you
time.
can't get a parawise comment.
No, Lordship, the last communication is
Powerful
of
government
23,
advocate of
Lordship.
Gauhati High Court not being able to get a parawise comment.
I will take up the matter, Lordship.
Miss U. Sharma submits that she be granted further 3 weeks time to file, to bring on record the stand of the respondents represented by her by way of filing an affidavit. Prayer accepted. Registry to list this matter again after 3 weeks. Interim order passed earlier to continue till the next date of it.
Highly obliged.
Other cases you want a date, take it from her. What is it?
Regarding pensionary benefit.
Today it's 4:30. We can't, we have.
No, a date.
She'll give you a date, don't worry. Date Milai Diniva.
36.
36, Lordship has already heard the matter.
31.
31.
31.
31, my lord. I have prepared a written submission, my lord.
Oh, we'll have to hear it. Some issues are there. I'll have to hear it once. Date did you khali thaka din dibo. You do one thing on the date when it is listed. If I have some delivery of orders, I'll do that.
Fine.
I'll treat it as it's a parted already.
Yes.
So just make a mention, we'll take it up early.
Fine, my lord. Fine. An item.
That police wala, that
Police,
RPF,
constable, RPF constable.
29:30. One lady was there.
Yes.
Yes.
All the witnesses deposed. I was not there at that point.
You nothing. Rather, we'll have to now impose the penalty on the Director General of RPF.
No, it's not like that.
Yes, Mr.
29:30, my friend is there.
29:30.
These cases will never reach. এইটো এটা এনেকে এটা টিটত দিয়া য'ত মেটাৰ নাই মোৰ তাতে আহিব জি বেঞ্চ এণ্ড অল
Miscellaneous there. That's
23/6. Hopefully that day.
Yes.
Make a mention. These cases are pending. It's not reaching. But
We'll make
when
a
it's
mention
listing,
in the-
kindly mention. We'll take it up early.
Yes, my lord. It can be
Because
done.
these cases cannot go to before any other. I'll have to do
Yes,
it.
correct, correct.
So I'll have to take it up. Other cases, she'll give you date.
Deeply obliged.